Estoy here, so. Not on mute, right? Mhm.
All right, ladies and gentlemen, I have about 9 o'clock. I'm going to call the criminal and then the civil dockets. I'll ask for announcements to the attorneys. Anyone who's present who either doesn't have an attorney or your attorney's not here, make sure I know you're here. But if you're not actually addressing me, folks, because I've asked you to, keep your electronic devices muted, please. State versus Donald Fletcher.
Judge, I spoke with Adrian Pettis this morning. Mr. Fletcher is at his office. That is going to be for entry of a plea. And Mr. Pettis said that that he has a sentencing in Bexar County at the same time. So he's going to jump on as soon as he can get done with the sentencing.
He said he'd be in about 10 o'clock. He also has Atascosa County as well.
Okay, but does his client need to be at probation and rather than Mr. Parrish's office?
He is going to need to meet with probation. I don't know that his client knew how to use Zoom. And so he was trying to have him in his office to go through the paperwork and use the Zoom.
Okay, but how are we going to get a thumbprint?
I agree with you, Your Honor. I'm just relaying the message.
Okay.
Mr. Pettis.
I'm not advocating for this. All right.
I am not advocating. I'm just relaying the message.
Okay, I will mark him no show for the time being.
Okay.
Jose Hernandez, MTR. And let me ask, why are these 4-year-old cases on just for arraignment?
With Mr. Fletcher's case, that was an outstanding warrant.
Okay.
That case got indicted. There was a warrant issued, and I'm guessing he just got arrested on it because Mr. Pettis just popped up with it.
Okay, thank you. State versus Jose Hernandez.
He was given notice to be here, Judge. He's not here.
No show. I'll recall Amber Barnett. It says via Upton County Zoom. Is
And Your Honor,
on?
and that's going to be a plea, Your Honor. I'm not sure if they're on.
They're in the corner. I see them.
Okay, I've got 2. Does it say Upton County?
It's all I see is it says booking. Miss Barnett, can you wave your hand?
Yes, ma'am.
Okay, that's Upton County. All right, thank you. Jesse Aguirre.
He's on, Your Honor, and he is in custody in Bandera County.
And Your Honor, that's going to be a plea on both cases, correct?
Yes.
Okay.
Each of us have a case.
Ramon Frausto.
Here. In custody, Karnes County.
All right. Patricia Peralta. Patricia Peralta, no show.
Your Honor, he's in custody in Zavala County. We were late in getting them.
Oh, Patricio. Okay, he's in Zavala County.
Yes, he should be on shortly.
Thank you. Adriana Saldana.
Good morning, Your Honor. She's present with counsel. This was just to monitor PTD, whether she went last week, which I believe she did. So I guess that's it.
Yes, Judge. She completed all her paperwork, so she does not need to be on the docket for today. Everything's done.
All
May
right,
we be excused, Your Honor?
That's all you have. Yes, sir.
Thank you, Judge. Ms. Saldana, you're good to go.
Julian Alba,
Courtroom.
Not present in the courtroom, Your Honor, but I did show that he had Albert Quiteres retained. And no show as well for the attorney.
okay, Albert who?
Albert Quiteres,
QUI?
GU.
Oh, Gutierrez, okay.
Thank you, Your Honor.
All right, thank you. I'll mark him no show. Johnny Ray Frausto,
Not present.
all right. Mr. Vargas is just checking in. Jose Nunez,
Not present in the courtroom.
here comes Mr. Perez. All right, Mr. Vargas, are you?
Judge, I checked. He was given a PR bond, and deputies there believe he was he's homeless, and I have not been able to communicate with him.
All right, thank you. Luis Aguilar,
Your Honor, Attorney Briggs called us this morning. He is running late. He's also doing a docket in Atascosa County. But no sign of defendant.
mark him no show for the time being. Jesse Aguirre,
Here, sir.
Same announcement, Your Honor.
okay, this is the one where Ms. Roberts has the other, okay.
Yes.
Patricio, I assume Peralta,
Judge, I'm here. I'm also zooming with Judge Ellison, so bear with me. I don't know where he is. Last I checked, he was in the Zavala County Jail.
Same announcement, Your Honor. They were getting him ready. He should be on shortly.
We'll confer on that one shortly, Judge.
okay, and the first case on the docket was yours, I think, Mr. Perez. It was
Fletcher?
Yes.
Yes, sir. He's in my office downstairs in the waiting room. He has an old-fashioned phone. I told him to call in. We do have plea paperwork. We are going to plea that today. The next one on the docket, Judge Jose Hernandez, he should be in the courtroom. On that one, I'm going to need a reset if it's okay with the court. I need to talk to him about his case, get him into my office. We haven't really had a chance to meet up.
All right, he has not appeared so far.
Okay.
No
All right.
response.
All right, and well, Mr. Fletcher, is he going to sign the paperwork with you and then go to probation so that they can get fingerprints and go over the documents with him?
If he has to, he has to. I had him come here because he lives in San Antonio, but he is going to do the plea paperwork with me. It is for probation, and if he has to go to Pearsall, he has to figure out a way to get to Pearsall. I'll talk to him about that. I don't think it'll be a problem.
Your Honor,
Yes.
Your Honor, he just showed up. He is present in the courtroom.
He who?
Jose Hernandez. I'm sorry.
All right, thank you.
That's the case, Judge, where I'd like to reset it to get him into my office and have time to confer with the state and talk to him about his options. We haven't been able to meet at all, Your Honor.
Okay. Get with, not too long because it's an MTR, but please get with the coordinator's office and you can send that to me in chat. We'll reset it.
Yes, sir.
Criminal add-on, Sonny Viesca.
Not present in the courtroom.
He was given notice, Judge, when he was in jail, and he just got released, but he is not here.
All right, thank you. Elias Salinas.
Judge, he is not present. He was given notice. He picked up another arrest, and he was taken to Laurel Ridge, so he is not going to be here.
So he's in Laurel Ridge, you believe?
Yes, sir. I was told by the police department they took him to Laurel Ridge.
Okay. All right, we'll need to get him an attorney appointed. Victoria Hernandez.
Hernandez is a plea, Judge. She's in custody. Plea paperwork has been e-filed and accepted. You should have access to it. If not, I could post it in chat for you.
All right, I would appreciate that.
Yes, sir.
And there was nothing when I logged on to the judge's queue earlier this morning. All right, anybody else told to be here today just for a criminal case? All right. I am going to make Miss Riley the host so that you can speak with her about getting breakout rooms. I'll ask Ms. Riley if you would make me the co-host, I'd appreciate it. All right, civil cases in Frio County. Matter of the marriage of Keller.
Morning, Judge. I'm Ronald Ortman, and I'm an appearance attorney for attorney Jesus Lopez, and he asked me to enter a not ready announcement.
Okay, and I saw Mr. Ramirez.
Sorry, I'm here. I didn't unmute myself. Am I unmuted now?
Yes.
Okay, Your Honor, I'm sorry. I'm Tommy Ramirez. I represent the petitioner in this case, James Keller, who is also present. Mr. Lopez filed paperwork on this matter a few days back, and he asked me to agree to a continuance, which normally I have no problems doing. The concern that I have in this matter is that the holidays are rolling around. Thanksgiving is here in 14 days, and Christmas is, the school holidays begin less than 4 weeks after that. I need some rules in place and some orders in place so that the parties are able to navigate through the holidays without any trouble. And that's
Judge,
really all I'm after, which is why I told him I can't agree to reset.
Judge, if I may, Jesus's office tells me that they're available for November 23rd. So I think that would resolve opposing counsel's issues.
And that would, Your Honor, and I told Mr. Lopez I'm fine with rescheduling if the court's available, but the problem is generally this court only meets once or twice a month because it's got 5 counties to cover. And so
well,
I'm fine with
that is a Frio County day, but thanks to the miracle of Zoom, we have a lot more flexibility.
Okay, well, I'm good. The 23rd is open for me.
All right, so 11:23 temporary orders.
Okay, same time, 9 a.m.?
Yes, sir.
Oh, excellent, Judge. Thank you so much, and thanks to opposing counsel for being flexible. We appreciate
Hey,
it.
it's my pleasure, and tell Jesus that I'm glad that we could get a date before the holidays.
Okay, excellent. Thank you, sir.
Thank you all so much.
Okay, on the regular Frio civil docket, 11-6-191 in the interest of Emma Stam, a child. I'll recall. Tax cases, Dilley ISD versus Donald Brown.
Good morning, Your Honor. Jeff Garcia standing in on behalf of Mr. Rocha. We are ready on this case. However, I have not had the ability to speak with the ad litem, Mr. Roberts. Looking at the Zoom meeting, I do not see that he was given an email notice on this on the document, so we may need to pass on that.
Okay, just reset on request?
Yes, Your Honor.
Dilley City versus Armando Olivares.
Your Honor, on this one, the ad litem, Ms. Rodriguez, has contacted our office on Tuesday, and she'd like to reset on request to allow her to do some more research on the case.
Okay. City of Pearsall versus Erasmo Garza.
Your Honor, we're ready on this case, but same announcement. I have not had the ability to speak with the ad litem, Ms. Carrillo. Let's just go ahead and reset on request.
Dilley versus Noelda Garcia.
Plaintiffs Dilley ISD and City of Dilley announced ready. So, Your Honor, Mr. Cabello, I don't know if he's on the Zoom meeting or not, but he has to go ahead and okay.
Judge, good morning. We're ready to. Intervenor from Frio County is ready.
Okay, I'll take all the tax cases at once, so I'll mark that with a T.
Thank you.
Pearsall ISD versus Hunter.
Plaintiffs announced ready.
Intervenor's ready, Judge.
Gilly versus Michael Stewart.
Plaintiffs announced ready.
Interveners ready.
Pearsall ISD and City versus Tony Perez.
And plaintiffs announced ready.
Interveners ready, Judge.
Right. In the matter of the marriage of Aaron and Joseph Martinez. All right, Mr. Molinar, Mr. Hicks. No show. 20-09247, in-ray structured settlement.
I'm here, Your Honor, and I believe Mr. Perez is here too. Ray, are you on the call?
I see a Ray's iPhone that is talking, but he's muted, so I'll mark you.
Okay. Thank you, Your Honor.
Okay. All right, would you post to me in chat a copy of your proposed order and a copy of your petition?
Sure.
Thank you. All right, and then one add-on from Atascosa County, 117714, Ms. Harkins.
Yes, Your Honor. Judge, that is just a quick motion, should take just a few minutes.
I'll mark you number, actually, I'll mark that number 1 since I need to look at the petition on the other side.
Yes, Your Honor. Would you like me to email you, or excuse me, post to the chat the proposed order and the motion?
Yeah.
Okay,
Yes.
I will do that.
All right, Karnes County, Lundberg versus Intervest.
Good morning, Your Honor. It's Alex Kaplan for the Intervest defendants, and the defendants are ready to proceed with the motions, Your Honor. There are a number of them. We've discussed with opposing counsel a potential sequence, but it's all time permitting with Your Honor.
Okay, I saw Mr. Quinlan, I believe.
Yes, Your Honor. John Quinlan is here for the Black Brush defendants.
Your Honor, Daniel Trust is here along with Spencer Cox and Trace on behalf of the plaintiffs, Lundbergs and Mithril.
And Your Honor, this is Amir Alavi. I'm here with Taylor Freeman on behalf of defendant Magnoli.
Your Honor, Derek Cook for the Compass defendants.
Okay. And you're announcing 2 to 3 hours?
Yes, Your Honor.
Okay. How many pleas do you expect we're going to have? Is Ms. Carranza still on? Yes.
I'm here, Judge. We have 2 pleas with Jesse Aguirre, 1 plea on Donald Fletcher, 1 plea on Veronica Hernandez. I think that's it. So 4. Oh, Amber Barnett. I'm sorry. 5 pleas.
Okay. Thank you. All right, and 19-4-106 in the interest of RJO and RIO. I saw Mr. Braswell, I believe.
Yes, Your Honor, this is a modification. I have put that into the chat.
Okay, and Mr. Braswell?
Your Honor, it's just entry of an order is all it is. And there's one point of contention that I want to bring to the court's attention. So I would say probably 5 to 10 minutes is all we need.
Okay. All right, then I'll just mark you number 3. All right, on Lundberg, I don't see us getting to this much before noon. So I take it everybody's at their office plugging away?
Yes, Your Honor. We're at the court's convenience.
All right. Why don't I just read all this for noon rather than have y'all hang on and you're welcome to hang on and watch the pleas, other matters if you want.
That works for the plaintiff, sir. Thank you.
Problem with anyone?
Fine for
No,
us.
Your Honor.
And I'll ask you to confer in the meantime and see if you can agree on what order to hear these in.
Yes, Your Honor. Thank you.
Okay, all right. Look at some of these quick civil things, and then we'll do the tax cases and then the pleas. All right, Ms. Harkins, what's going on this case?
Your Honor, this was a receivership case in which you appointed Judge Bob Hurley as the receiver. There is money in the registry of the court that is awaiting an heirship proceeding. We had tried to file that into this case, and Ms. Littleton advised that her file had been closed, and asked me to get permission from the court to reopen the file. So that's all we're asking today, is for us to be able to reopen the file to do this heirship proceeding.
All right, let me get this saved and I will post it back to you. Actually, let me email it to you and to Chris Benavides. Or would there be somebody better in Atascosa County for a civil matter?
Judge, I think that Jackie is handling the civil matters, but I can call and let them know it's on its way to Chris. I'm sure that's fine.
All right. Okay, well then I'll just post this to you in chat.
Thank you, Your Honor. I received it, Judge.
Thank you.
Thank you. May I be excused?
Yes, ma'am.
Thank you, Your Honor.
All right, I'm looking over the structure settlement. All right, Ms. Evans, you ready to proceed?
Yes, Your Honor.
All right. And I'm going to ask Mr. Perez to raise your right hand. Do you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Go ahead, ma'am.
Thank you, Your Honor. Julie Evans here for Peachtree Settlement Funding. Mr. Perez, could you just state your name?
Raimundo Perez.
And are you currently a resident of Texas?
Yes, ma'am.
Do you have an annuity that's owned by Bright House Life Insurance?
Yes, ma'am.
And what you'd like to do is sell a single payment of $250,000 that's due to you in 2037. Is that correct?
Yes, ma'am.
In exchange, you would receive 70,000, which is obviously less than what you would receive in the future. Do you understand that?
Yes, ma'am.
Do you understand the discount rate is 8%? Or in other words, if this had been a loan, it would be a similar rate. Do you understand that?
Yes, ma'am.
Do you understand that the lump sum my client would pay you is all you will ever get for the lump sum payment you're selling in the future? Do you understand that?
Yes, ma'am.
Do you understand that even if the judge approves it, you still have a number of days to cancel or change your mind? But if you wait longer than that, you might not be able to undo it later. Do you understand that?
Yes, ma'am.
Did we advise you that if you had absolutely any questions about this transaction, that you should speak to your own professional, either financial or a lawyer, and they can answer any questions that you might have?
Yes, ma'am.
Okay, do you understand I'm not your attorney here today?
Yes, ma'am.
Okay. Could you please explain to the judge why you feel this is in your best interest?
Well, because I'm out of work right now, and I need to have back surgery or go through a lot of therapy, either therapy or microscopic surgery, and I'm not going to be able to have money to afford my bills and take care of my family.
I have nothing else, Your Honor.
Mr. Perez, are there other payments that you're supposed to receive from this annuity, or?
I got another one coming in 2 years.
Okay, and how much is that?
I think it's 75,000.
Okay. And how much investigation did you do before you settled on Peachtree? Anybody else? Or did you talk to any other companies about?
Yes, I talked to what was it, Settlement Capital, but they were gonna give me 50.
Okay. Have you sold any other annuities in the past?
Yes, sir.
Okay, and when was that?
About 7 years ago.
And how much did you receive for that annuity?
66,000.
And did you, what did you do with that money?
Sir?
What did you do with that money?
Well, I had to borrow my friend's truck, and I rolled over on that truck, so I had to pay for his truck. And then I had to pay some medical bills for my wife because she has lupus.
Okay.
And she had to go through what do you call it, ovarian cancer. She had to get her ovaries burned.
All right, I'm sorry to hear that she's going through all that.
Yeah.
All right, sir, I will approve the sale. Give me just a moment to try and find the. All right, Ms. Evans, and that's the clerk's office. I've just posted those two orders in chat.
Excellent. Thank you, Your Honor.
Your excuse. Have a good day.
Oh.
Okay, are you ready on the tax cases?
Yes, Your Honor, we're ready.
Right. Go ahead, sir.
At this time, Your Honor, plaintiffs make an oral motion to consolidate all the cases in which plaintiffs and intervener are announced ready.
No objection, Judge.
Without objection, that motion's granted.
At this time, we further ask the court to take judicial notice of all documents and citations in the court's file, that all necessary parties were properly served and failed to answer or answered and duly notified today's court setting and did not appear.
Okay, I'll take judicial notice of the entire content of the court's, but I'll need to go back and look at those before I sign anything.
Yes, Your Honor. For the court's record, on the last case, the Tony Pettis case, that defendant did answer pro se back in September of 2019. We did send a notice of the setting on August 10th, 2020. We'll provide that in addition to our exhibits. And we further, at this time, offer the evidence which have been previously marked as plaintiff's exhibits, showing all the delinquent taxes, penalties, and interest, showing due and owing to the plaintiffs and intervener. And we ask that those exhibits be admitted into evidence.
No objection, Judge.
Without objection, all of the exhibits are admitted into evidence.
And finally, Your Honor, plaintiffs and intervener pray for judgment in favor of plaintiffs and intervener.
All right.
That's correct.
And have you e-filed the proposed orders? Are they in the files?
No, Your Honor, what we did to, for the court's sake, we will e-file those judgments and the exhibits later today, so that we wouldn't have to previously e-file like the cases where we passed on, right?
Sure. Okay, I appreciate that.
We'll get those to the court here shortly. Yeah.
All right, then you are excused, and I will look these over. In the
All right, thank you, Your Honor.
files.
Jeff, that does include the county certified tax statements, right?
That's correct, Mr. Cabello. We went ahead, everything that you get filed from a judge will include the intervener for Frio County and also the plaintiffs, the school districts, and the cities.
Yeah, thank
All
you,
right,
Jeff.
thank you.
Thank you, Judge. May I be excused?
Yes.
Thank you, Judge.
Thank you, Jeff.
All right. All right, Ms. Hellrung, Mr. Braswell.
Yes, Judge.
Okay, you said there's a disagreement about some part of the temporary order.
Yes, Your Honor. The order is good all the way through, but on page 12, she has a finding. It says the court finds that petitioner counter respondent Tisha Marie Castillo resides at 11207 Sageville Drive, Houston, Texas 77089. We did not litigate that issue. The court did not make that finding. Frankly, the mother took it upon herself to move from Karnes County or Wilson County all the way to Houston, uprooted the kids. The dad doesn't know what school they're in. She's acting autonomously. And I just feel like this is an underhanded way of trying to, litigate a major transfer of over, 200 miles where these kids are living. We didn't even address that issue. It was a modification, Judge. We didn't address the issue of whether she could or could not move. And so we dispute that the court made such a finding because I don't think you did.
Your Honor, if I may, we
Yes.
had this hearing. At the hearing, we announced the move, and the court did make did comment that in a video that Mr. Rowland made of his son and told his son he didn't have to move to Houston, you stated you were concerned because it wasn't up to an 8-year-old boy to decide. It was mentioned, this is not underhanded. We advised the court at the last hearing that she was moving. Mr. Ortiz knows exactly where they are. They have the address. My client has provided all of the information regarding the school. And I think this is just an attempt to try to subvert what has already happened. The fact is it a finding? Okay, maybe not. But at the end of the day, she's moved. And she moved the day after the last hearing, which was 2 months ago. So they would have to uproot the children. She also is married. Her husband lives in Houston, and she got a promotion, and she is living there and has been for the last several months.
Is this the individual who's an attorney for rural legal aid or not, or Texas legal aid?
No, she is a CPS worker. She works for the Department of Family and Protective Services.
right.
And she was promoted and received a job in Houston.
But she had not moved as of the time on September 2nd?
She moved on, she received the job on the 1st. We announced that she was moving the very next day at the hearing on September 2nd.
All right. And Mr. Braswell, I mean, has she moved to one to that address at Sageville Drive in Houston?
Judge, she has now, but she hadn't as of that time. And it was done without consulting with the father. And this is a case, Judge, where we were granted a new trial. My client has a standard possession order, and we have never litigated the issues of conservatorship. Now, granted, I think it's probably going to be a JMC either way we cut it, but this is a case that is far from over. And for the mother to unilaterally just pick up and move 5 hours away, without getting any approval from the court. I know there's not a standing order in Karnes County, but most places wouldn't allow the kids to move without the court, ruling on that issue. And I feel like in this case,
Mr. Braswell, you're mistaken. There is a standing order for all 5 counties down here.
well, Judge, it would appear that she would have violated, because one of the standard terms is that you can't move the kids out of the county. You can't just pick up and leave. And just as my client's starting his SPO, she up and moves to Houston.
Your Honor, I would object on the grounds we did announce to the court at the last hearing that she was moving.
All right.
And during the school year, by the way.
Okay. She had not moved as of September 2nd, so I will strike this finding. I don't know that it makes a difference one way or the other, but she had not moved as of September 2nd. I'll strike this finding. Are there any other objections to the terms of the order? I mean, to the form of the order, not the contents?
No, Your Honor.
Your Honor, I would, however, get a finding today as to the fact that she has in fact moved, as opposed to having to relitigate this move and uproot the children.
Well, I would argue surprise, Judge. We're not here to do anything but enter an order. And I think you've made your ruling, and we're good for the order to be signed now.
Okay. I've already signed it. I'm going to save it and I'll post it back. And is the Karnes County clerk online? I didn't.
Yes, Judge, we are online.
Okay, I'll just post this, sign this and post it back. And I'll ask you to file it.
Okay.
Your Honor, do I need to set it for hearing on the move? I'm just asking.
I have no idea. I mean, even if I find she's moved, I don't know if it's a good thing or a bad thing, or if it's relevant to anything. I'll let you make that.
Your Honor, I think that if she will call me, perhaps we can address this issue outside this hearing right now.
Okay, because I mean, I'll agree with Ms. Hellring that either she has or she hasn't. It sounds like there's no dispute that she has, but if it's not before me today, it's not before me. All right, so I have posted that. And do you have any other settings, or is this just reset on?
No.
No, Your Honor.
No, Your Honor.
All right, so I'll put temporary order signed. Reset on request. And you're both excused.
Thank you.
All right, let me go back up to the top and start looking at the plea papers I was sent. All right, Mr. Perez, are you online?
I think he went to Bear County, Judge.
Yes, I'd seen him sign on and off a time or two. All right, the Hernandez plea packet is corrupt. If anybody else has a copy of it that works, that's fine. But whenever I have downloaded it, it will not open up. All right, and Jesse Aguirre, is that the one that Mr. Ernst has also?
Yes, Judge. Mr. Ernst has the 2009 cause number, I believe, and Katie Roberts has the 1907 cause number.
Okay.
And that's correct.
All right, and do I have the plea package on your case, Mr. Ernst?
Yes, Your Honor. Yeah, plea paperwork was turned in yesterday.
Okay, well, but I don't have a copy of it, so.
On the Aguirre one, if that's the one y'all are discussing, I think we need some thumbprints on it. And so we were getting with Bandera County.
Okay, let me know when you're finished or you're ready.
Okay, thank you.
I'm emailing you the plea paperwork.
I have it already. I already have.
All right. Well, if you'll send me a copy of it, and then if we can get the prints from Bandera in advance, that would be good. If not, we'll go on.
Judge, and while we're waiting, I just want to let the Frio District Clerk's Office know that the judgments for Jesse Aguirre that were sent to you yesterday are incorrect. Please do not use those. I will send you the new ones shortly. And please don't send those from yesterday to Judge Wilson yet.
Okay, thank you.
Thank you.
All right, Mr. Hicks, were you able to get logged on?
Yes, sir. I am here now. I apologize.
All right, that's in the matter of the marriage of Aaron and Joseph Martinez.
Correct, Your Honor.
All right, and what announcement do you have?
We're announcing ready, and time announcement is going to be, I'm assuming, probably about an hour. I've been unable to speak to Mr. Molinar up to this point, so.
Okay. And he is not actually, unless he's signed on, is Mr. Molinar online? There was no announcement earlier.
Okay, let me see. I don't. Yeah, I don't see him on here right now, Your Honor. Like I said, I called yesterday, I left a message and had not heard back from him yet. This is a matter for temporary orders on this case. We are the respondents, but we're the ones who actually set for this hearing because the petitioner has not allowed my client to have access to the children. So we filed our counter petition and set for these temporary orders. I believe this was originally set or originally filed in September, but nothing has happened up to this point.
All right, sir, I'm going to ask you to check with Mr. Lenar's office and see if you can find him and report back that to me. And also, if you can't, let me know what service or notice he had of this hearing.
All right, Your Honor, we'll do. Thank you.
And is somebody working on getting me Mr. Aguirre's other case paperwork?
All his plea packs were given to the respective attorneys and they should have all been done and sent back for you. And the current judgments have been sent to the district clerk's office.
Okay, Mr. Ernst emailed something not in chat, so let me open this up. All right, calling State versus Jesse Aguirre. Are both sides ready?
Defense is ready, Your Honor.
Defense is ready, Your Honor.
Okay, are you Jesse Aguirre?
Yes, sir.
Is that your true and correct name?
Yes, sir.
All right, Mr. Aguirre, can you speak, read, and write the English language?
No, sir.
All right. Is there another language that you're able to speak, read, and write?
Spanish.
Okay. All right. Let me ask you, have you been able to understand what your attorney, Mr. Ernst, has had to tell you about your rights and your options?
A little bit, sir.
Okay. Would you be more comfortable if you had an opportunity to have an interpreter work
Yes,
to make sure that everything was read to you in the Spanish language?
Yes, sir.
Okay. All right, let me ask the coordinator's office if it's possible, given that we're all on Zoom, just to call and see if there's an interpreter available right now. And we'll be in recess on this hearing until we find something out about that. And my Acrobat's locked up, so let me see. Okay, and has anyone been able to get another copy of the Veronica Hernandez plea package? Because again, my copy is corrupt. I think that's just an issue with it coming over Zoom.
Dahlia, do y'all have the Veronica Hernandez paperwork?
Sorry, Leslie, we were having difficulties with our mouse. Yes, we do have the plea paperwork, and we just received the judgment from you a few minutes back. We're just waiting to get her thumbprint, and we'll send it to you.
Okay, well, we don't have to wait to do the plea on the thumbprint. I mean, we'd like to get it as soon as possible, but start the plea.
Joanne is working on the PSI.
On Veronica?
Yes.
Okay, could I ask, do you all have the paperwork, or does Judge Wilson have the paperwork on Amber Barnett?
We do not have any documentations on Ms. Barnett.
Kyle Ernst?
I e-filed that yesterday, or even before that, and it said it was submitted.
Is that what you filed? You were talking about this morning?
If you all could please check that, because Mr. Ernst is here and so is Ms. Barnett, and Adrian Pettis is not. And
Yeah, I filed this paperwork on November 3rd, so a while ago.
Yes, we did notice that you did e-file it, but we wanted to wait till court because we wanted to know if Judge Wilson would like it through chat or through e-file.
I would, anything that we're doing online in Zoom, I would always prefer to have that in chat.
Okay, so tell Esperanza to accept it, and then that way we can get it through chat.
Okay, Your Honor, we'll get it together.
We'll be already.
Judge, on
Yes.
Roman Frausto, he's here. I don't think he's had an attorney appointed yet. I don't know if they've done that. You got the paperwork on that. I think they mailed it back Tuesday.
In the US mail?
No, email
Email
to the court coordinator.
to where?
Court coordinator.
To the court coordinator.
All right, I'll ask Ms. Riley to look into that and see if she or Ms. She has that.
Can you repeat that? I'm sorry. Check my email for which one?
Roman Frausto should have had the paperwork to get an attorney appointed. Came from June Lynn.
When was that sent? On Frausto, it's Robert Vargas was appointed.
Can we see if we can get him back online? He's already left, I believe.
Yes, sir.
Your Honor, I'm back. Can I make a brief announcement, sir?
Yes.
For Jose Hernandez, he's the MTR, and I have Fletcher in my office right here with me. We have a deal. He can't get down to Pearsall. I told him I would take him to Pearsall, but I'd like to see if you would reset both Hernandez and Fletcher to November 23rd. That's about 2 weeks from now on a Monday. It is your docket. I'll take them down. I'll take him down myself and we'll get it done.
All right. Give me a moment.
Yes, sir.
Right. Okay. Is there any objection from the state?
No, Your Honor, I've already discussed it with Adrian. That's fine with me.
Okay, and that was on Fletcher and Hernandez both?
Yes, sir. And if you want to go ahead and put Peralta there since he's in custody, that's fine. I thought he was going to be out of custody, and frankly, I still need to talk to Ms. Carranza and Patricio about that one. We still do have a plea on Veronica, though, Hernandez.
Okay. All right.
Your Honor, this is John Hicks here. I've got an update for you.
Yes, sir. Go ahead.
Yes, sir. I have attempted to call Mr. Molinar again. I left another message for him. He did not answer. However, I was able to find our notification of service that we've got here for the e-service. We filed our notice of hearing for temporary orders on October 20th at 3:14 p.m. And Mr. Molinar was one of the service contacts that's listed here to show that he was given notice of this hearing.
Okay. Do you want to swear your witness in?
I'm sorry, you cut out. I'm sorry.
You want to swear your witness in?
Yes, Your Honor. I mean, we're just we can do that. And then we can just do, obviously, an order to come on the temporary orders, but we can definitely have him testify as to what we're asking for in our temporary orders.
All right. Go ahead, sir.
All righty.
Who's your witness?
This is Joseph Martinez, Your Honor.
All right. Mr. Martinez, will you raise your right hand? Do you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir. I do.
All right. Go ahead, sir.
Yes, Mr. Martinez, can you please give your full name for the court?
Joseph Torres Martinez.
And are you currently married to Aaron Martinez?
Yes, sir, I am.
And are you guys currently separated at this time?
Yes, sir, that is true.
And are we here to establish some temporary orders in this case? Actually, let me just strike that. Did Ms. Martinez file a petition for divorce in this case?
Yes, sir, she did.
Okay, and that petition was filed on or about September 10th of 2020, is that correct?
Yes, sir, that is correct, sir.
Okay, and have you had any hearings or court dates before today?
No, sir, I haven't.
And recently, has Ms. Martinez denied you access to your children?
Yes, sir, she has.
And how many children do you guys have together?
We have two, sir, a 5-year-old and a 3-year-old.
Okay. And you have been having sporadic electronic access to them, is that correct?
Yes, sir. We do have FaceTimes here and there. But yes, sir.
Okay. But that has not been done on a regular basis, is that correct?
That is correct, sir. It hasn't.
And so today and that's why you hired us, so we could turn around and move this case forward and allow you to have access to your children, is that correct?
Yes, sir. That is correct, sir.
Okay. And today you're asking the court to grant you extended standard possession order, is that correct?
Yes, sir. That is correct.
And then asking that Miss Martinez be granted primary, is that correct?
Yes, sir. That is correct.
And then you're also at this time willing to pay the guideline child support, is that correct?
Yes, sir. That is correct as well.
And then you would still have access to your home that you're currently living in, is that correct?
Yes, sir.
That's all we have right now, Your Honor.
All right. Sir, have there been any criminal charges filed against either spouse in the during this marriage?
No, sir.
Have there been any Children's Protective Services cases opened against either spouse?
No, sir.
Okay, I will. And has your wife been a resident of Frio County and the state of 90 days in the state of Texas for 6 months before the lawsuit?
Yes. Yes, sir, she is.
All right. Anything else, Mr. Hicks?
No, Your Honor.
All right. I'll find I have jurisdiction to hear this matter, and I will grant the relief prayed for on temporary orders and ask you to get that reduced to writing and to me. And with that, you're excused.
Thank you, Your Honor. Yeah, we'll have that to you today, Your Honor.
Okay.
Thank you.
Thank you, Your Honor.
All right, let me ask the coordinators off. Actually, Mr. Vargas is here. Ms. Riley, could we get him with a breakout room with his new client in Karnes County?
Yes, sir.
And have we heard anything from interpreters?
No, it's like on there. I remember.
Your Honor, we're still working on that.
Okay, thank you. I'll note, I'm not sure we'll be able to do this today regardless, because I'll note that the interpreter's portion of the plea papers have been redacted.
Your Honor, I'm sorry. You had that divorce here, and was November 23rd good for those three clients?
Yes.
Okay, yes, sir. And I'll stand by for whenever you're ready for Ms. Hernandez. I'm ready when you are.
Your Honor, can I be placed in a room with Mr. Aguirre?
Okay, I'm not doing the breakout rooms. Ms. Riley is, so yes, you need to address her.
I just did a breakout room for Karnes County Sheriff's Office and Roberto Vargas, but I'm still showing him here. I don't know if it went through or not. And Katie, you need to be with Jesse Aguirre, and he's in Bandera.
Yes, ma'am.
Okay, let me see if I can do that.
All right. Deputy Reyes, if you're able to just move the cursor down to the bottom of the screen, it should have breakout room come up and then click on join. Okay, Veronica Hernandez. This time it was not corrupted.
Go down.
Also on Mr. Aguirre, on Mr. Ernst, on your Aguirre plea, I did not get any of the attachments with the state's exhibits.
I can get that over to you right now, Judge.
All right, and all right, calling State versus Veronica Hernandez.
State's ready, Your Honor.
Defense ready, Your Honor.
You're bringing her, Judge,
Thank you.
and paperwork was just sent to you.
Yes, I just got it. Thanks.
Judge, and just for your information, I can see that Jose Nunez has popped up on our Zoom hearing. He was not here right when we called it. His lawyer is Fausto Sosa. He's at the bottom of page 2.
All right, I've only got one page.
Yeah.
Okay, I see Mr. Nunez. All right, did Mr. Sosa answer?
Judge, I don't know where I'm getting this information. I know I've heard it. I think Mr. Sosa's been ill, and I don't think he's been to the last few court settings, but I'm not exactly sure where I heard that from.
All right, Mr. Nunez, what can you tell us about where your attorney is?
I need an interpreter.
Oh, he needs an interpreter.
Okay. Un momento.
Thank you.
I'll give it a shot. ¿Dónde está su abogado?
En el hospital.
No. Ms. Riley, I know you're jumping around. If you could try and give Mr. Sosa's office a call, I'd appreciate it.
Yes, sir.
All right, and is that Ms. Hernandez who appeared?
Yes.
All right, calling State versus Veronica Hernandez. Are both sides ready?
State's ready.
Defense ready.
Okay. Are you Veronica Hernandez?
Yes, sir.
All right, I'm going to need to ask you to speak up, ma'am, because the reporter needs to take your words down. Ma'am, can you speak, read, and write the English language?
Yes.
And are you a United States citizen?
Yes.
Despite your representation that you are a United States citizen, I need to caution you that if that is not true, any plea of guilty by you or finding of guilt by me could result in your deportation or exclusion from this country and or a denial of naturalization benefits. Do you still wish to enter a plea today?
Yes.
Okay. And I'm sorry, I got distracted for a moment. I'm not sure if I asked you this or not. Can you speak, read, and write the English language?
Yes, I can speak and read and write the English language.
All right, thank you. All right, ma'am. Do you have any history of mental health problems or mental illness?
No.
Counsel, do you believe your client's competent to stand trial?
I do, Judge. Also, I'd like the court to take judicial notice that she was given a competency examination and found competent.
All right. Without objection, I'll take judicial notice of the entire contents of the file. All right, ma'am, you stand charged by indictment with the first-degree felony offense of aggravated assault with a deadly weapon. Specifically, it's alleged that in Frio County, on or about July the 8th of 2019, that you intentionally, knowingly, or recklessly caused bodily injury to Juan Martinez, the complainant, a member of your family, as described by the family code, by cutting the complainant with a knife, and that you did then or there use or exhibit a deadly weapon, a knife, during the commission of that assault. That alleges a first-degree felony, which in Texas is punishable by confinement for not less than 5 years and not more than 99 years or life, and by a fine not to exceed $10,000. So do you understand what you're charged with and what the range of punishment is?
Yes, sir.
Okay. Do you understand that the plea bargain agreement you have with the state is not binding on me? I do not have to follow it, but if I decide not to follow it, I will allow you to withdraw your plea.
Yes, sir.
So you understand that. What I'm saying is whatever you and the state and your attorney have worked out, I don't have to go with it. But if I don't go with it, you don't have to worry that you've already pled guilty or no contest and it's too late. If I don't go with the plea that you've worked out, I'll let you, with the agreement that you've worked out, I'll let you take your plea back. Do you understand that?
Yes, sir.
You understand that if I do approve the plea you have worked out and the sentence I impose is not harder on you than what you have agreed to, you will not be able to appeal this matter?
Yes, sir, I do understand.
All right, and you understand that if your plea bargain agreement is for deferred adjudication probation, and I would follow it, I would find there was enough evidence to say that you were guilty, but I would not do so. Instead, I would defer or put off any finding of guilt, and I would put you on deferred adjudication probation. And if you successfully complete that deferred adjudication probation, the case against you will be dismissed and you'll have no conviction. But on the other hand, if while you're on deferred adjudication probation, the state alleges that you have violated the rules of your probation, then you could be found arrested and brought back to court. And if it turns out that it's true that you have violated the terms of your probation, then you could be found guilty and sentenced to anything that's a legal sentence for a first-degree felony. 5 to 99 years confinement and a fine up to $10,000.
Yes,
You understand? Okay. I want to show you some documents that appear to have your signature. They're titled Admonitions to the Defendant for Plea to the Court. And let me ask you on paragraph 2.11, is this your signature?
Yes, sir.
And at verification?
Yes, sir.
And do you swear or affirm that everything that appears above your signature on verification is true and correct?
Yes, sir.
Did you also sign at the certification of appeal?
Yes, sir.
Agreed punishment?
Yes, sir.
Waiver of preservation of evidence?
Yes, sir.
And the discovery certificate?
Yes, sir.
There. Okay. All right. Did you read these documents yourself, or did Mr. Perez read them to you before you signed them?
They were read.
Did you understand all of these documents before you signed them?
Yes, after he read them, yes.
Okay. And are you satisfied with the work?
Excuse me?
The work that Mr. Perez has done for you?
Yes, I'm satisfied.
I'm sorry, I couldn't hear you.
Yes.
All right. Counsel, do you believe that your client understands the nature of the rights she's giving up, the stipulations of evidence she's making, and the consequences of her plea bargain?
Yes, sir.
All right, ma'am, I'll find that you made your waivers of right and your stipulations of evidence knowingly, intelligently, and voluntarily, and I'll ask you to the offense alleged in the indictment, aggravated assault with a deadly weapon, first-degree felony, do you plead guilty or not guilty?
Guilty.
I'm sorry?
Guilty.
Okay. Has anyone promised you anything other than your plea bargain with the state to get you to plead guilty?
No.
I can't hear you, ma'am.
No.
Okay. Has anybody harmed or threatened you or anyone close to you to get you to plead guilty?
No.
Has anyone promised you an early release from your sentence?
No.
Okay. I'll find that you made your plea in this case voluntarily and you're not under any compulsion in making it, and I'll accept it. And I'll ask what evidence the state has to, pardon me, substantiate the defendant's guilt.
State's Exhibit 1 and its Attachment A, Your Honor.
No objections, Your Honor.
All right, without objection, State's Exhibit 1, its Attachment A are admitted into evidence. Do both sides rest and close at this stage?
Yes, the state does, Your Honor.
Defense as well.
All right. Okay, give me a chance to look at the attachments. All right, I'll find there is enough evidence to substantiate the defendant's guilt. Are both sides ready for sentencing?
State's ready, Your Honor.
Defense ready.
All right, has there been a pre-sentence investigation done?
I believe Ms. Gonzalez had worked on that and it's finished.
Yes, Judge, that was sent to you.
It was sent to me how?
Did you send it? Veronica?
Okay,
Did we send in Veronica Hernandez?
I got the package from the clerk's office. I did not receive the
Yeah.
pre-sentence investigation.
I apologize, Judge. It's still sitting there on the desk. She needs to scan it real quick.
Your Honor, while we're waiting for them to scan that to you, I can see that Ms. Riley says there is no interpreter available today. So could
Yes,
could we put Jesse on 1123?
Yes.
Okay, and that way Bandera County can get off, and I guess Ms. Roberts, if she doesn't need anything.
All right, Ms. Roberts, I know Mr. Perez is already on for 1123. Are you available?
I believe so, Your Honor.
Yeah, and I'm available, Your
Oh,
Honor.
actually, Mr. Ernst, it was, not Mr. Perez.
Yeah.
Okay.
I'm available, Your Honor. That's fine.
All right, and you may just need to start over on the plea papers because we need to have the interpreter's part filled out also.
Okay.
Will do.
Your Honor, Mr. Peralta was on Zavala County, and he's been moved to 1123, so I guess they can log off. They're done.
Is that all that Zavala County had?
Yes, sir. Was
Okay, I'm sorry.
Go ahead.
All right, well then we'll release Zavala County and Bandera County.
Yes, sir.
All right.
And Judge, we heard back from Fausto Sosa. He's not available. He's in the hospital. And his assistant said they did e-file a waiver of arraignment, and it was e-filed. I don't know if it's been accepted by the district clerk's office yet.
Okay.
That's with Jose Nunez.
I was supposed to call her. Yeah, it's, I didn't pick up.
Okay. And on Veronica Hernandez, let me go ahead and ask, pending receipt of the pre-sentence investigation, are both sides ready for the sentencing hearing?
State's ready, Your Honor.
That's ready.
Okay, what is the plea bargain in this case?
The plea bargain agreement, Your Honor, is 6 years deferred adjudication, a fine in the amount of $1,500. She is to attend and complete an anger management class, a batterer's intervention and prevention program. She is assessed court costs in the amount of $249. She's to do 200 hours of community service at 16 hours per month. She's to pay a one-time drug test fee of $50. She is to take an education, drug, and alcohol evaluation and follow all recommendations. She's to pay a family violence center fee of $100. She's to have no injurious contact with the victim. She's to pay $60 per month probation fee, a one-time $25 PSI fee.
It always has to be like that.
And she is to be evaluated, have an
You
evaluation
download the document as well, right?
and adhere to those recommendations. And I would also like to put on the record, Your Honor, that I spoke to the victim in this case in August 13th of 2020. He is on board with the plea, and I spoke with him again this morning, and he's aware of the plea. They are married, they are still married, and he is ready for her to come home.
All right, let me ask Ms. Hernandez, is that your plea bargain with the state?
Oh, yes, sir.
Did the state's attorney add anything or leave anything out?
Yes, sir.
I'm sorry?
Yes, sir.
Okay, what was added or left out?
What is it? It was one of the programs.
Judge, I think she misunderstood the question. Ms. Hernandez, is this the same thing that we talked about on video conference?
Yes.
All right, and I've received a copy of the judgment from the district clerk's office. I still need a copy of the PSI.
Your Honor, I attached everything together. I'll double check and I'll resend it.
Oh, I see, it's the back of it. All right, never mind, I'll just delete it. So give me a chance to look at the. All right, so let me back up. I want to get sidetracked. All right, so ma'am, that is then your plea bargain with the state?
Yes, sir.
Okay, all right. Let me look at the PSI. And ma'am, do you have any children?
Yes, sir.
How many?
6.
And how many of them have graduated from what, high school?
None yet.
All right, ma'am. And how long ago was it you were in the state hospital?
A month ago.
Okay. And has the defense had a chance to look at the pre-sentence investigation?
No, Judge, I've actually not.
All right.
I'm sorry. I thought I had it. I don't actually have it.
Okay, I'm just posting it to you in a private chat.
I received it, Judge. I'll open it right now.
All right, ma'am. And when was the last time you were employed?
2010.
I can't hear you.
That was like 2 years ago.
And what sort of work were you doing?
I was housekeeping.
And is there any reason why you didn't get a job after you are out on probation?
Can you say that again?
Are you planning to get a job and be employed after you get out on probation?
Yes, sir.
All right. Mr. Perez, have you had a chance to look over the?
Yes, sir. I have now. No
Yes, ma'am.
objections.
All right. Okay. I will follow the plea bargain agreement in this case. I found enough evidence to substantiate the defendant's guilt, but rather than find her guilty, I will place her on deferred adjudication probation for a period of 6 years. I am going to zero out the fine, but I will leave everything else the way it is. I'm doing that because I don't find that Ms. Hernandez has a great deal of earning capacity. And if she has 6 children, I think she's got plenty that she needs to be spending her money on. I want you to remember what I talked to you about, ma'am, on deferred adjudication probation, that if you successfully do everything you're supposed to do, the case against you will be dismissed and you'll have no conviction. But the state, as I said, if they believe that you're not following the rules, they can file papers that say you're not following the rules. And if that happens, you could be arrested and brought back to court. And if we find out that it's true that you've been violating the rules of your deferred adjudication probation, then you could be found guilty and you could be sentenced from anywhere 5 to 99 years in prison and fined up to $10,000. But on the other hand, as I said, if you do everything you're supposed to do on deferred adjudication probation, the case against you will be dismissed and you'll have no conviction. And on this would not be eligible for a order of non-disclosure for family.
No, sir.
Okay. All right. Now, you're still going to be ordered to pay money on this case because of the fact that you have court costs and you have supervision fees. I'm not at all telling you that it's not important to make those payments. It's very important that you make those payments, but if absolutely the only thing that you're doing incorrectly is that you're not making all of your payments on time, we're not going to bring you back to court and find you guilty just for that. We'll give you a chance to make larger payments towards the end of the 5 years, and if or 6 years, and if absolutely necessary, you could even have your term of probation extended. So I want to make sure that if a month rolls around where you are unable to pay your fees that are due, that you don't fail to go and report just because you don't want to show up and tell your probation officer that you don't have the money, all right? So you understand that because I have followed the plea bargain agreement in this case, that you have waived the right to appeal and you may not appeal?
Yes, sir.
All right, I'll find that you made your post-trial waivers knowingly, intelligently, and voluntarily, and I will approve them also. And I will certify to the Court of Appeals that you've waived the right to appeal as part of a plea bargain and you have no right to appeal. I wish you good luck, ma'am.
Thank you, Judge. That's all I have. May I be excused?
Yes, sir.
Thank you.
All right, I just posted the plea papers and the judgment. So we have a plea on Amber Barnett.
Yeah, did we lose her? Did Upton County get booted out?
Yeah, I don't see him any longer. And do I have any paperwork on Barnett?
Yes, Your Honor, I just sent it.
Oh, just now, okay.
Yes.
Oh, I see it. Yes, 1032, all right.
I don't know what happened to Upton County. I still see Zavala on there, even though they're done. I don't know. They were on. And I don't know if Mr. Frausto and Mr. Vargas had an opportunity to go to a breakout room or not.
Yes, I did. I'm going to get them to sign a waiver arraignment, and then I'll confer with you, see if we can reach an agreement on this matter.
Okay. Thank you.
All right, and I have the judgment on Barnett. I do not have the plea package.
I'll resend it again, Judge.
Let me see if I can get a time.
It wasn't all together.
Frio County, can you tell me if you have the waiver of arraignment on Jose Nunez?
We're gonna have our clerk find out right now. We noticed that it was on e-file, so we'll have to print it out and send it through chat.
Okay, thank
Okay.
you.
Can you just save it and send it through chat?
Yes, Your Honor, we can do that. Is it Kyle there?
Leslie, Kyle, Amber Barnett, they had to put her away because they have court going on also. They wanted to know if they could have a exact or more specific time when they need her in front of the camera.
Now.
Now.
All right.
That work?
Was ordered to the court coordinator yesterday. Yesterday, Esperanza put on here. Yes, that's the one we spoke about this morning. Did you talk to her about it?
No.
Yes.
County again.
Yes,
While
ma'am.
we're waiting, can I go over the document real quick?
Yes.
So starting on the first page, Lori, are you ready?
Yes, I am.
Okay, first page, Donald Fletcher is being moved to 1123. Jose Hernandez is also moving to 1123. Hopefully we're going to do a plea on Amber Barnett shortly. Jesse Aguirre is moving to 1123 and he will need an interpreter.
Okay, we'll make sure that's available.
Okay, Roman Frausto, they're working on a waiver right now, so we'll get that hopefully. Patricio Peralta is moving to 1123. Andrina Saldana is a pretrial diversion and her paperwork was done and she's finished. Julian Luz Alba, ISHO did not appear and I do not know if any waivers of arraignment were done. Johnny Ray Frausto, that belongs to Mr. Vargas and he did not, Mr. Frausto did not appear and I don't think Mr. Vargas knows where he's at.
Right.
Okay.
Frausto's homeless and I'm not been able to reach him.
I understand. Jose Nunez, he is on the Zoom and we're checking to see about his waiver of arraignment.
There was one e-filed and I just forwarded it to the judge.
Okay, I just don't know what the dates are on that. What
Let's
it's
look. Let me look real quick.
okay.
Okay.
I apologize. Frausto is in custody. He's signing off on a waiver.
It's a
Johnny
different
Ray-
waiver. It doesn't have a date, I don't believe. It's a different waiver than the one we use.
The one I use, I just the exact wording that you use on yours. I just rewrote it on my.
It doesn't have a date on it though. But
Right.
All right.
Yeah.
So Johnny Ray Frausto is in custody?
Yes, Your Honor.
Okay, because I had him as no show, but
In what county, Mr. Vargas? Is it in Frio? Is it us?
Carnes.
Where's Carnes? Javier.
Good.
Hey,
Let's
y'all
just
have
put-
Johnny Ray Frausto?
Yes.
No.
That's Johnny Ray. Roman Frosto.
yeah, that's what I was thinking.
No, they have Roman Frausto, not Johnny Ray.
Johnny
Ray's homeless. He's my cousin.
They got the wrong one. You sent the attorney's.
So that still stays as a no show. Okay.
Yeah, she's the wrong one.
Frausto, got it.
Mr. Vargas.
Okay. Luis Jose Aguilar, I'm showing did not show up.
Correct.
Okay. Jesse Aguirre on the last page is set to 1123. Patricio Peralta is set to 1123. And then on the add-ons, I show Sunny Viesca did not show up. And is it Elias Salinas or Elias Salinas? Did not show up.
But they're in Laurel Ridge.
Oh, right, in Laurel Ridge, you're right. Yes, sir. I don't know what would you like to do with that one?
We'll appoint an attorney.
Do you want to put
Brittany
it?
Roberts is the next up on the will, I believe, Judge.
Okay.
And do you want to put it on the 23rd to follow up or something different?
23rd, just to follow up.
Yeah.
I don't know if that's a 72-hour commitment or a 6-month treatment.
I don't know. I'll try to find out before then. And then Veronica Hernandez, we just did the plea on.
Right.
Okay.
And Judge, on Elias Salinas, are you gonna appoint Grady Robertson on that one?
Yes.
On that Nunez case, the reset date on the arraignment should be 1/7/2021, but it's not in the order. Do you want me to add that on there? On the e-file
Yes.
document, Judge?
Please. Okay.
Judge, I'm being told by the bailiff that Upton County is in the middle of a parole hearing. So they're
Okay.
going to get Amber Barnett out when they're done with that hearing.
Okay. We probably have limited facilities. Isn't that pretty low population county?
I don't even know where it is, but I guess.
Far up north, I think. Northwest Texas,
Maybe.
Upton County. Population 3,600.
Wow.
Yeah, it's south of Odessa. Saw somebody on the internet complaining this week that there were counties in Texas that have over 100% of their adult population as registered voters. And one of them was, I think, Usher County, and one was McMullen County. They've only got 300 adults, so if they've got, 400 registered voters, I don't think that's not saying there weren't a lot of problems, but that's not one of them.
Yeah.
All right.
Judge, a correction on that Nunez e-file. It was sent back to the district clerk's office. And I'm getting an error message when I'm trying to send it to you, but I believe Frio County has it, so.
Okay, if you can just download it as a PDF and email it or post it in chat, that's fine too.
I'm getting an error message. I'm not even sure if I can even do that, but I'll try.
Okay.
It was already sent in the chat.
Oh.
Okay, what was sent in chat?
Nunez, she just did it a little bit ago.
Oh, okay, yeah, here it is.
I can't even get out of it now.
Sometimes it sends me a message that says that I have a new chat message, and sometimes it doesn't. Okay, so what date do we need to give Mr. Nunez?
January 7th, 2021, Judge.
All right.
Yes, we don't want to see that.
Okay, I've just posted the waiver back. It's set for January 7th.
So Mr. Nunez is free to go.
Yes. Señor Nunez, 7 de enero,
Okay, yes,
January 7th. Thank you.
thank you.
Huh?
Oh, I see. I didn't put granted or denied, so let me go back.
What? Yeah.
All right, I'm reposting the order with a X on granted. Okay, anything else we're ready on right now?
The only thing I have is Amber Barnett. I don't know, are Mr. Vargas and Mr. Frosto done? Did you get their waiver?
Not yet.
Okay.
Oh, good Lord, I get all kinds of messages here.
Leslie, we're still waiting for the correct waiver to come through with the right name on it.
Oh, does it have the other guy, Johnny Ray?
Yes.
Okay, we need Roman. Yeah, I got it.
Waiting for him to send it.
Okay, thank you. Frio County, did we have a waiver on that Julian Luce Alba?
Oh, Leslie.
No?
No, I'm not showing anything.
Okay, all right, just checking. Thank you.
Thank you.
All right. I'm gonna go grab a cup of coffee. It usually takes about 10 minutes. Hopefully they won't come back, Upton County, or, so I'll be back in just a few minutes.
Thank you. Frio County, if Upton County pops on and we're not on, hang on to them, okay?
Yes, ma'am, we will.
Thank you.
Thank you.
And you're probably, if you don't have it, you'll probably have to get it wherever you got the paperwork from. It's probably that Texas.gov.org. Yeah, if you don't have that filled out, the rest of your literacy, Friday before the hearing, so you have to the one. Court will be done by Zoom, so I'll need to get an email address where we can forward you that link for Zoom the day before. What's the email address? Let me make sure I have that code. Isaac, ISAAC, the letter N, and CASS, CASS 2018@gmail.com. Okay, we'll go ahead and forward you the link to the day before, or the Friday before court. And that's how you will log in the morning. It's at 9 a.m. November 23rd. He did sign a waiver, but you can forward him that link to his email. Okay. Thank you. I already told him no on this. You mind calling him back? I already told him no. Yeah. Yeah. And I emailed him that too. Oh, you just did? Yeah, I don't know when they called me.
Yeah, I would call and just say, your person knows you and you want this because he's not receptive for the time. Okay. Yeah. I'm not receptive on it. Oh, on that TRO, it hasn't been signed or anything. Yeah, because they're waiting for a date. Okay. Yes, yes. Thank you.
Is this Upton County?
Yeah, that's Upton County. That's Amber Barnett sitting there.
Okay.
Thank you.
Want to double check. Thank you.
Don't go anywhere, Amber. We're trying to get to you.
All right, I'm back. I do not see Upton County yet. Is that correct?
She's.
They're here, Judge.
Oh, I had changed the name before to say Upton County, but, okay, all right, I appreciate y'all. And I wasted my time. The water main is off and Circle K has no coffee. Our restrooms are soda water. So hopefully we'll get that fixed. They did 8 o'clock this morning. Okay, and have I received the plea papers on Ms. Barnett? I had the judgment.
Yes, Your Honor, I sent it to you. I'll double check again.
Okay, here's another Barnett. Yes, you're right. Okay. This would be it. All right. Ms. Kronza, have you had a chance to look at the papers as they've come back?
No, Your Honor, I sent everything in the order it needed to go to you to Mr. Ernst.
And I think it probably still is. It's just, I'm not sure that it's legible, what's come back.
I don't see them again unless somebody posts them on a chat for me to look at. I don't know what they looked like when they get sent to you.
I'll post it to you, Leslie.
Okay, thank you.
Here, I've got it. It's probably legible.
And I think that's because I'll check on the original, because when they get faxed over, that's what has been happening.
Yeah, I know.
Yeah.
I am always trying to get us to do it electronically and not acoustically. Ms. Kronz, I haven't looked at the whole thing. I think I can make that out mostly.
All I can see that they sent to me in the chat is the judgment. I don't see the.
Oh, I sent you that. I guess I sent you the wrong one. Let me see.
I sent you the plea, Leslie.
Okay, okay, I see that there's two here. Maybe I just didn't click on the right one.
Okay.
Let's try again. Here we go. Let's see. Oh, I see. Yeah, it doesn't look good. I don't know why it looks that way.
All right, let me ask the folks here in Upton County if we emailed or if we posted in chat a copy of the plea papers. Are you able to open it up and look at a PDF? Just Adobe Reader is all you need. Just anything that will read a PDF. And we haven't sent you anything. All right, I just sent Upton County the copy that we can't read very well.
And Judge, I have my actual file with me, so I can give you information if you need it.
I can read most of this. I mean,
I know.
I'm not going to have to defend it on appeal. That's why I wanted you to have a chance to look at it.
Yeah, I don't know why it looks that way.
Let me ask, up to booking, were you able to download the document I sent you?
Found it. I guess it's the same, but we're putting it out right now.
Okay, but are you able to open it up and look at it?
Yes, sir.
Okay, Mr. Ernst, if you could send the clean copy before it's not the facts of the facts.
Email a copy.
Just post it in chat.
I gotta be able to email because it's through my phone and I don't have the document on my phone.
Okay, send it to me and I'll post it in chat. Because I don't know what their address is booking. And Mr. Vargas, were we able to get the waivers signed and for Mr. Frausto?
He's signing on it. I'm just in the process of sending it to you now.
Okay. All right. Okay, well, this is actually a full copy.
Yeah, that's
good. It's a fax, but it's legible.
Well, yeah,
Okay.
that's the one I had filed, e-filed.
Okay. Calling State versus Amber Barnett. Are both sides ready?
Defense is ready.
State's ready, Your Honor.
Okay. Are you Amber Barnett? I can't hear you, ma'am.
Yes, Your Honor.
Okay, are you the same Amber Barnett who, on or about May the 9th, 2019, was placed on 4 years deferred adjudication probation for the third-degree felony offense of assault of a public servant. You understand, ma'am, that on that day, the judge found there was enough evidence to say that you had violated, that you had committed that offense, but the judge did not find you guilty. Instead, you were placed on deferred adjudication probation, which means that if you successfully complete your probation, the case against you will be dismissed. You'll have no conviction. But the state has alleged that you violated the terms of your deferred adjudication. And if they can show that that is true, then you could be found guilty today and sentenced to anything that is a legal sentence for a third-degree felony, 2 to 10 years in prison and a fine up to $10,000. You understand that?
Yes, Your Honor.
Now, the state alleges that you have violated rule number 11 of your probation in that you failed to report to your probation officer as you were ordered to do so. Specifically, they allege that you failed to report to your probation officer in the months of August, September, and November of 2019. So do you understand what the state is alleging that you did wrong?
Yes, Your Honor.
Do you understand that the plea bargain you have with the state is not binding on me? I do not have to follow it, but if I decide not to follow it, I will allow you to withdraw your plea.
Yes, Your Honor.
And if I do follow the plea bargain and the sentence I impose is not harder on you than what you have agreed to, you will not be able to appeal this matter?
Okay, yes, Your Honor.
Right. I want to show you some documents that appear to have your signature. They're titled Written Waiver and Consent Stipulation of Testimony. And let me ask, on page 3, is this your signature?
Yes, sir.
And do you swear or affirm that everything that appears above your signature is true and correct?
Yes, sir.
Did you also sign a plea bargain agreement?
Yes, Your Honor.
Waiver of time to file motion for new trial?
Yes, Your Honor.
And the court certification of appeal?
Yes, sir.
Okay. You read these documents yourself, or did your attorney, Mr. Ernst, read them to you?
I read them myself and we went over them.
All right. Did you understand these documents before you signed them?
Yes, Your Honor.
And are you satisfied with the work Mr. Ernst has done for you in this case?
Yes, Your Honor.
Okay. Counsel, do you believe your client understands the nature of the rights she's giving up, the stipulations of evidence she's making, and the consequences of her plea bargain?
Yes, Your Honor, she does.
All right, ma'am, I'll find that you made your waivers of right and your stipulations of evidence knowingly, intelligently, and voluntarily, and I will ask you to the allegation that you violated your deferred adjudication probation by failing to report to your probation officer. Is that true or not true?
True.
I'm sorry?
True.
Okay. All right, I'll accept your plea of true, and I'll ask what evidence the state has to substantiate the violation.
State's Exhibit 1, it's attachment A, Your Honor.
No objection.
All right, without objection, State's Exhibit 1 and its attachment A are admitted into evidence. Do both sides rest and close at this stage?
State does.
Defense rest and close.
All right, I'll find that there is enough evidence to substantiate the violation. And also a change needs to be made in the disposition of this case. Are both sides ready for that hearing?
State's ready.
Defense is ready.
Is there a pre-sentence investigation or a waiver of one?
A waiver of a PSI.
Okay. All right, what is the plea bargain in this case?
The plea bargain agreement, Your Honor, is that the defendant be adjudicated and a finding of guilt be entered, that her probation be revoked, that she be sentenced to 3 years confinement in the Texas Department of Criminal Justice, the Institutional Division. This is to run concurrently with any other sentence she may currently be serving, and she's to receive credit for all the time that she served on account of this case. And we show that as 145 days.
Okay, ma'am, you heard did you hear what was read in the record by the state's attorney?
Your Honor.
I'm sorry?
Yes, Your Honor.
Okay, is that your plea bargain?
Yes, Your Honor.
Did the state's attorney add anything or leave anything out?
I don't think so.
All right, well, I have to be certain that this is your agreement. Do you need to hear the terms again?
Yes, please.
I'm sorry, Ms. Cronz, if you read the terms again?
Yes, sir. Ms. Barnett, the terms were that your probation is being revoked, that you're sentenced to 3 years confinement in the Texas Department of Criminal Justice, the Institutional Division. This time is to run concurrently with any other case you may currently be serving, and you're to receive days credit for all the time you've served already. And I show that to be 145 days.
Okay. Am I eligible for parole?
I'll talk to you about all of that.
Okay, thank you. I
Right
understand.
now. All right, so is that your agreement, your whole agreement?
Yes, Your Honor.
And let me ask, is there an agreement about a yes or no agreement on a deadly weapon finding, or I don't know if there was a deadly weapon allegation?
No.
There was not a deadly weapon allegation, Your Honor.
Okay. All right. And Mr. Ernst, what sort of other charges is your client facing, or do you know?
She's currently, she has a pending charge in Upton County. I'm not sure off the top of my head exactly what it is.
It's abandonment, endangerment.
Okay, yeah.
Okay.
I have an open CPS case.
Okay. And ma'am, have you had a chance to talk to your attorney in the CPS case about what being confined in prison will do with your ability to comply with any orders of the court in the CPS case, as far as if you were ordered to take classes or treatment or anything else?
To take classes while I'm in prison, Your Honor?
Well, no, that's what I want to know. Have you had a chance to talk to your CPS attorney about how entering this plea may or may not affect your CPS case?
No, Your Honor, I haven't.
All right. And do you want a chance to do that before I finalize this plea?
Yes, Your Honor.
Okay. How? All right. What I'm going to ask you to do is I'm going to ask Ms. Riley to place Upton County and Mr. Ernst in a breakout room, and you can talk with him, and then you can, if necessary, get your attorney's information, and if at all possible, we try to get your attorney online today at this hearing, so we don't have to come back, and we'll be able to dispose of this today. Hopefully your attorney in your CPS case can make an appearance during the Zoom hearing and talk to you in a breakout room.
And Your Honor, I just want to put on the record that her attorney in Upton County, that information was given to Mr. Ernst. He's received it. Joanne Gonzalez gave it to us. I believe her name is Lily Plummer. So, I mean,
Now,
I know
is that in the criminal side or on the CPS side?
Both sides, Your Honor.
she's saying both sides. Both.
My lawyer. Yes, sir.
Well, that makes it a lot easier. Okay. All right. So I'll ask. Well, Mr. Ernst, so you have the contact information then for?
No, I don't have the contact information.
Okay.
Kyle, can you please check your emails with Joanne? Because I know that you received that because I was on there as well.
I'll double check.
We sent it several times.
All right. So we'll be in recess for a few minutes. Let me ask Upton County, do you have other hearings that you need the Zoom room for?
Yes, sir. We have county floor for our county. Just one person for Zoom. It started at 11, so I'm not for sure, where's he at on the.
All right. Well, if you need to start that with county, if you need to take her back, that's fine. Go ahead and do that, just as long as we have Ms. Barnett come back and we have some answers from her attorney.
Yes, sir. Yes, sir. Will do.
Okay.
Are we good to go? Are we excused? Your Honor?
Well, again, no, we're not,
Okay.
we need her. If you need to do things in county court, I don't know how long it's going to be.
Oh, I don't know either, sir.
You can swap, take her back but no, we need you to, if you need to sign off, as long as you come back, we'd appreciate it.
Okay, yes, sir.
Okay, so I'm not placing them in a breakout room at this time, Judge? As I'm having a-
Right, Mr. Ernst just needs to see if he's able to contact the attorney and see if we can get some answers right now.
Okay, I was having problems with it right now anyway.
Are y'all taking me back to my cell?
No, just
wait for a second. Okay.
Forgot to turn the ringer off after I went and failed to get coffee.
Judge, I send you the waiver through your email address on Mr.
Oh,
Frost's.
yes. Okay,
And also put it on the, it's also put it noted on your, as you like it.
thank you. I'll post this right back.
Maybe excuse?
Yes, sir.
Thank you.
Wait, what was the date on Roman Frosto?
11/23.
11/23. Got it. Thank you.
Are we done?
Yes, sir. Thanks a lot.
Bye, Karnes County.
Okay, thanks.
Stay up, Ma. Okay.
And is that all that Kearns County had?
Yes, sir.
Okay. All right. Thank you. So is he saying, say you tomorrow to you or?
I don't know, Mr. Frosto, so
Oh, okay.
I don't know.
All right. I just sent the waiver of arraignment of Mr. Frosto.
Okay.
And could I be put in a breakout room with Miss Barnett?
Yes, let me get you in there, okay?
Okay.
Can I join this?
Mr. Briggs?
Good morning, Your Honor.
Morning.
I'm appearing on a Luis Aguilar 2008092 CRF. And frankly, I have no knowledge of whether he is in custody or on bond.
Well, he did not appear. It says arraignment, but it's an August case. Do we know, has he appeared in court before, or did it take a while to find him? If you know.
I have not had any communication with him, Judge. I sent a letter to his home address and have received no response from that. So I was assuming he was in custody based on that, but I suppose I could check with the sheriff's office and see if they can tell me.
All right, well, let me ask the clerk's office, did he make bond on this case?
As we know, he is not in custody. Let me see if. Check.
And Judge, I have an announcement on Miss Barnett whenever you're ready.
All right, yes, sir. Go ahead.
I just spoke with Miss Barnett, and I also spoke with Miss Plummer's law partner. She's currently in a hearing right now. Miss Barnett would prefer to speak with Miss Plummer, so I'm requesting a reset to 11:23, and I'll get everything set up so she can meet with Miss Plummer, so she knows exactly what was going to be going on with everything.
Okay, all right.
Oh, Your Honor, on Aguilar, we show that he signed out for bond October 1st of this year.
Okay.
May I be excused, Your Honor?
Yes, sir. I mean, fine, Barnett. Was she?
She's right there.
All right, I see. Okay, so I'm going to put 11:23. Okay. And I'll hold on to the waivers and everything for right now. We'll just suspend the plea. I don't want to have motions for new trial come in saying that it wasn't voluntary because it affected her CPS case.
Okay.
Get that figured out up front, whether there's effect. Okay. All right, then you are excused. Upton County is excused. I appreciate you working with us.
Thank you.
Is that everything on the criminal?
It is, Your Honor, other than the court, just if you would call those nice eyes for me.
Yes, if the clerk's office will have the bailiffs do that. And on Mr. Alba, did we ever work out if there was or was not?
The clerks are saying that they do not have a waiver of arraignment on Julian Alba. And Lori, do you have anything or show anything?
I don't.
Okay, so I don't have anything.
Okay. All right, well, then we'll go ahead and call it. Yes, Mr. Bates?
Judge, if I may?
Yes.
On Mr. Aguilar, can we have the clerk's office confirm that he had notice of today's setting?
Your Honor, I'll check it right now, but I did show that he did have notice for today's date, yes.
He did. Okay.
Yes.
I just wanted to confirm that.
All right, well, then I think if you'll just get the nice size signed and emailed or posted to me, because I'm going to be online with the Kearns County case for a while.
Yes, Your Honor, we'll do that.
All right.
Sorry.
Everybody else, go ahead.
Just quickly, Frio County, I'm showing it's Julian Luz Alba, Johnny Ray Frausto, Luis Aguilar, and Sunny Viesca. Does that sound right?
Yes.
Yes.
Okay. All right. Thank you, Your Honor. May I be excused?
Absolutely. Have a good day.
All right. Bye, guys.
Bye.
All right, Lachey, did you want to take a break to get some lunch? I can't hear you. I'm sorry.
Yes, Judge.
Okay. All right, then. I think most of the attorneys are here. Several of them are here.
Oh, Judge, I didn't know they were here. Just give me a few seconds to open up a new file. I don't want to go to lunch.
Okay, well, it's still, I said noon, and I'm working on some other things over here, so
Okay.
we'll go ahead and start it and make sure you hit the time. All right, folks. My Adobe keeps locking up. My email has locked up. I can tell you from experience that the only thing to do is to reboot this laptop. So I'm going to go ahead and reboot my laptop. That usually takes 7 minutes or longer. So it'll be a little bit after the hour whenever I come back, but I shall return.
Okay, thank you, Your Honor.
Okay. My computer decided to go ahead and install some updates while I was trying to reboot, but I'm back. Who all is going to be speaking today?
So, Your Honor, on the defense side, we have several different lawyers going to present argument on different motions. I spoke, it's out for the record, Your Honor, it's Alex Kaplan for the InterVest defendants. I spoke with Mr. Terrest, opposing counsel, and we have an agreed sequence. So if it's all right with the court, the first motion that we would like to present argument on is defendant's motion for summary judgment based on the rule against perpetuities. And Mr. Olive, counsel for the Magnolia defendants, will be presenting argument on this motion for the defendants, Your Honor.
This is Daniel Schroes for the plaintiffs. I agree with what Mr. Kaplan said. On our team, Mr. Cox is going to handle the opposition to the motion with respect to rule against perpetuities.
Okay. All right, and what is the next motion after that?
The second motion, Your Honor, would be defendant's motion for partial summary judgment based on lack of title. And Mr. Freeman, counsel for Magnolia, will be presenting argument on that motion for the defendants.
And on behalf of the plaintiffs, I'll be handling that one, sure rest.
And Your Honor, depending on how, time permitting after that, I think the next motion that will be up will be the plaintiff's motion for partial summary judgment on the issue of mutual mistake. And if we get through that motion, Your Honor, after that, there are two discovery motions on the docket.
With one note, right, that on one of the discovery motions that pertains to Attorney Harvey, his lawyer has a 2 p.m. hard stop, so that will just push to the next hearing date if we can't get to it, which it seems like we won't, but that's the plan.
That's agreed, Your Honor, if that's all right with the court.
Okay. All right. So, Mr. Alavi, did I pronounce that correctly?
You did. Well, you did. It's
Alavi.
Alavi.
Alavi, okay.
Thank you, Your Honor. And is it possible for me to share my screen? I think that's set up. I have a few slides.
Yes, the council can share screen. You don't have to ask. I mean, assuming you're speaking.
And let's see if that's, let's see if this works. Can you see that, Your Honor?
Yes.
Great. Thank you, Your Honor. Amir Alavi on behalf of the Magnolia defendants, and I'll be arguing on behalf of all the moving parties on this partial motion for summary judgment on the rule against perpetuities. I should, to help orient the court, this motion is targeted to what the parties call the LOPCO back end. And more specifically, it's focused on the concept of its application as to future interests. It also applies to what the parties call existing interests. That's not the subject of this motion. We intend to file a motion as to that point at a later time. That's a little bit more complicated, has some additional property law issues. So we thought we'd go with the first easier motion. And I should note that there's a disagreement between the parties as to whether or not the LOPCO back end even applies to these future interests. And there's a contract interpretation motion that's been filed but not set today. And so I wanted to make sure the record's clear that by moving on the rule against perpetuities, we're not taking the position on behalf of the defendants that this contract even covers these future interests. And with that, there's been a lot of ink spilled on this motion. There was our motion, there was a response, there's been an amended response. But despite that, we think this is a very straightforward application of the rule against perpetuities. The LOPCO back end is an option. It's an option that vests upon the occurrence of a defined term called project payout. Project payout, in turn, and this is the problem for the plaintiff's claim, is not a particular period in time. It's a financial calculation. It's a break-even point when costs and revenue, and it's a little more complicated than that, are even, project payout occurs. And fundamentally, because of that, there are numerous contingencies. If you just sit back, logically think about when revenue may ultimately, net revenue, catch up to all the expenses, including investments, that option could vest in 10 years, 15 years, 25 years, 30 years. And as a result, because there are contingencies upon which the option could invest in greater than 21 years, it's void under the rule against perpetuities. And if I can help orient the court, there are several agreements at issue in this case. And the first agreement is an AMI agreement that was entered into on September 24th, 2001. And that was an agreement between Compass and Lopco. Compass was the original owner of the mineral interests, and Lopco entered into an agreement to purchase them and develop those mineral interests. So they entered into an AMI on September 24th, 2001. And that AMI contained a backend for Compass. That's what the parties refer to as the Compass backend. It's not at issue in this case. That's not the backend we're talking about with respect to this motion, but it was an original backend that Compass retained when they sold the mineral interests to Lopco and entered into the AMI. And that had a 12.5% back-end interest, and it had a concept of a project payout. And ultimately, 2 months later, on December 2nd, 2001, and this is the agreement that's going to matter for purposes of evaluating the rule against perpetuities, Compass and Lopco amended the AMI to provide for a new definition of project payout. And if you see on the right-hand side, we have the definition of project payout. This is Exhibit 13 to our motion. And if you go back to look at the exhibits, we actually filed this with our notice of hearing. So it's not in the original set of exhibits that were filed. We had a supplemental set of exhibits that we filed, and this is Exhibit 13, and it's paragraph 7. And what the parties ultimately agreed to is, you can see at the bottom right-hand corner, there's the defined term project payout. And project payout is defined as the date when essentially you get break even on the project. You have subparts A and B, and those have to equal the sum of little 1, little 2, and little 3 under the definition of project payout. A and B are, for example, net sales from all the wells within the AMI, so the net revenue that comes in. And there was also a gas plant that was included as part of this transaction. So little b is the revenue from the operation of the plant. And when that equals, then you have costs, little 1, little 2, and little 3. And those are $2.7 million, which was the original purchase price that Lopco paid to Compass. Little 2 are the costs of acquiring leases in the AMI and other expenses associated with leasehold acquisition. And then little 3 are the costs, including maintenance, for example, and expansion of the plant and gathering system. When those two even out and they equal each other, you have a date that's defined as project payout under the AMI amendment on December 2nd, 2001. Fast forward a little bit later, and we have the agreement that creates the Lopco backend. These are dated December 19th, 2001. What Mr. Lundberg, the principal of Lopco did is he was looking for investors to fund the project. And he entered into 21 separate investor agreements that are called the participation agreements. We have a sample of that at Exhibit 2. We have the remainder of those participation agreements in a block set at Exhibit 12. They're all the same for purposes of the language at issue in this case. And so Mr. Lundberg, on behalf of Lopco, entered into a series of participation agreements. And those participation agreements have language that creates the Lopco backend that's at issue in this case and for this motion. And this is the Lopco backend. It's at page 4 of Exhibit 2, the highlighted language. And at its core, it's an option. It's an option that when Lopco exercises the option, allows him to back into a 25% working interest into the leases. And the trigger date's at the beginning of the highlighted provision. It's a defined term, project payout with quotations. And what they ultimately do is they define that in the parenthetical, which is defined herein. That's classic definitional language, to have the same meaning as defined in the AMI agreement. And that's a classic. We already have a definition. So for this agreement, look to the definition that's created in the AMI agreement. And that's the language that I showed you on the previous slide on Exhibit 2, which is the expense, the project payout at the bottom is the date on which essentially revenue equals expenses. If you think about it this way, they could have just repeated the definition. And instead of doing that, they just refer to another definition. As you're reading this agreement, if you were a contract lawyer and trying to put together all the terms, you would literally cut and paste the definition out of paragraph 7 of the amended AMI and insert it into the participation agreement to interpret this contract.
Okay, and let me ask, all of the exhibits, are they in the appendix? I have a document, first motion for partial summary judgment, but that says against Mithral's claims. Am I looking at the wrong document here?
No, Your Honor, and let me back up. So Mithral is the successor to LOPCO. LOPCO is the original entity. There is a purported assignment to Mithral. We have some motions on that, but Mithral is the plaintiff that claims to be the successor to the LOPCO backend. So as I speak about the LOPCO backend, I'm talking about Mithral's claim in this case. The exhibits are in the appendix, save for that exhibit 13 that I spoke about. We filed a supplemental exhibit with our notice of hearing, and I believe that's in the Dropbox that we sent to the court yesterday with all of our exhibits.
Okay, because when I pull up the appendix, it says Exhibit B. They're not numbered with.
Okay, and that means, Your Honor, I think what you're looking at is you're actually looking at the plaintiff's exhibits to their response. So if you look at the actual defendant's motion, our exhibits, I think we didn't coordinate this, but it worked out well. Our exhibits have exhibit numbers, and Mithral's exhibits use exhibit letters. And if you need a moment to find that, happy to wait for you to be able to pull that up. We're able to find it, Your Honor?
No.
Let me see if I can find we sent a Dropbox link yesterday. Mr. Kaplan, do you recall when we sent that link with the courtesy copies of all the exhibits in the briefing?
Okay, I found 2 Dropbox links. I downloaded a whole bunch of documents.
Let me see if I can help with that, Judge.
I have a folder titled Defendants Motion for Partial Summary Judgment, read the rule against perpetuities. But whenever I click on that, it's empty. I also have a folder that just says defendant's motion, and that has defendant's first motion for partial summary judgment against Mithral's claims for future interest. But whenever I go to the appendix to it, that's where it starts out with Exhibit B. Oh, well, when I look at the bottom. Okay, so your exhibit numbers are at the bottom of the page?
Let me double check that. Yes, Your Honor. Bottom right-hand corner.
Okay.
Oh, so yeah, so the Exhibit B that you're looking at, Your Honor, I get it. That's from the original document. At the very top where it says Exhibit B and right below it says area of mutual interest. Okay. That's because the area of mutual interest was originally an Exhibit B to a larger transaction document.
Okay, I had this on page width and I've switched it to page height. So now I can see I wasn't seeing the bottom of the pages. All right. Go ahead, sir.
Sorry about the confusion, Your Honor.
It happens.
Let me-
Really huge monitor so I can see the whole page and read it at the same time.
Yeah, Your Honor, I have to tell you, I'm at home today, but my office, I have two monitors, one of which is vertical and one of which is horizontal, so that I can see long documents on one of the monitors. I have it rotated and it actually helps. These monitors are not set up for Zoom hearings, unfortunately.
All right, I hadn't thought about that. Okay, well, I'm gonna have to figure out a way to take my second monitor and rotate it. That would be great. Okay, go ahead.
All right, may I proceed, Your Honor?
Yes, sir.
Okay, so I think I was just walking through Exhibit 2, the participation agreement and the LOPCO backend, which is highlighted, and the way it defines project payout by referring back to the definition of project payout in the AMI. And effectively, from a contract interpretation perspective, it's not controversial. That means that when you get to project payout in the participation agreement, you look at the amended paragraph 7 of the AMI, and that's the definition of project payout, which is the date on which essentially net revenues equal the investment, the break-even date. And so ultimately what we have, Your Honor, are two sets of agreements. On the left-hand side, you have the AMI agreement, which was entered into in September of 2001. That creates the Compass backend, not at issue here. It defines project payout through the definition in the amendment. And interestingly, the AMI has an express expiration term in paragraph 6. The AMI agreement, and I'll show you that a little later, expires in 20 years. Then you turn to the participation agreements on the right-hand side. That's the agreement that creates the LOPCO backend. It refers to the definition of project payout in the AMI. So whenever you see the word project payout, you flip to that amendment on December 2nd, you read that definition. It has no expiration in the agreement. You can flip through the participation agreement. Unlike the AMI, it doesn't have a clause that says this agreement expires on this date. It's perpetual. And importantly, it doesn't have language incorporating the terms of the AMI. You don't have a paragraph in the participation agreement that says all of the terms of the AMI are incorporated into this agreement. Now, don't get me wrong, it refers to the AMI. It, for example, uses the definition of project payout in the AMI, but it does not have a wholesale incorporation of the terms of the AMI, including the expiration paragraph in paragraph 6. So with that background, we turn to the rule against perpetuities. And the critical question is there a contingency in which the option, the LOPCO backend option, could vest longer than 21 years? We don't have to deal with the life and being concept for the rule in the rule against perpetuities because there's no life and being named. So it's just is there a contingency by which the backend would vest in greater than 21 years from inception, viewed from the time that the agreement was entered into? And first thing you look at is there some type of explicit expiration? There isn't. So what you have to look at is the triggering event of the LOPCO backend itself, which is project payout. You have to ask yourself, could project payout, that triggering event, is there a contingency by which it could take place more than 21 years after the agreements were entered into? And to figure that out, you have to look at the definition in the AMI. And we've seen that before. That's paragraph 7. It's the project payout is tied to revenue. And nowhere in this definition does it have a time frame associated with it. Project payout, the defined term at the bottom of the right-hand corner, is the date when the net revenue equals the investment. So you ask the question, at inception, could it take more than 21 years to get there? And the answer is yes. And you don't have to take my word for it, but it makes common sense, right? These expenses include lease acquisition costs. If you are going to expand the plant and gathering system, if you're going to replace compressors, those are all investments that go into the ledger versus the net revenue. And we've all seen, for example, with the coronavirus, oil prices are volatile. You could make a $50 million investment one year, and it could take decades to recover that investment when you have situations like this year where the oil well, price of oil at the oil head was negative. But you don't have to even take my logical analysis for it. We asked a gentleman by the name of William Kasman in his deposition. He was one of the original participants, Your Honor. More importantly, he's the plaintiff's expert witness. He is the person they have put forward as an expert, an industry expert on the meaning of the participation agreements. That's in another motion we filed. And he was asked a fairly straightforward question about this calculation in paragraph 7. And it was a real world question. He was asked, you know that Enervest spent $100 million acquiring additional leases in the AMI. Enervest, one of the successors down the road, from Gulftex. Yes, I know that. In 2016, would that go into the expense side of the ledger? Of course it would. It's a lease acquisition cost, and he agreed to that. He said in 2016, because they spent $100 million, would that push out the date when project payout would eventually occur? And he said yes. Could it push it out 10 years to 2026? Yes. And he was asked, was it the intent of the parties that regardless of when project payout occurs, 2010, 2016, 2025, was it the intent that you would just wait and do this calculation, and when project payout occurs, it occurs? And he said yes. And that's the most logical reading of the definition of project payout. It's the only reading. It's the date on which revenue, net revenue, equals investments. And those investments are ongoing. And you knew that at the time that you entered into this agreement, because you knew you were going to be acquiring new leases. You knew you were going to be doing maintenance and expansion of the plant and gathering system. So there's no doubt that both common sense and the actual facts and the testimony of plaintiff's own expert, who was one of the participants, is that there was a contingency upon which this financial calculation could happen, equal out in 10 years, 15 years, 25 years, 30 years. And under the rule against perpetuities, it would be void. Now, the defendants will make their argument. They have they try to argue that somehow this definition disappears when the AMI expires in 20 years. I don't think there's a contract interpretation that gets you there. But assuming they're correct, that somehow when the AMI goes away, you stop doing this calculation. The definition just disappears. Now, again, I don't see how that could be the case. They could have defined LOPCO, saying LOPCO is defined in the AMI, referring back to the AMI. And when the AMI expires, the definition doesn't go away. The definition is the definition. But putting that aside, that argument doesn't save this under the rule against perpetuities. And that's because the triggering event, even if it was somehow tied to the expiration of the AMI can be extended by the parties. And because the triggering event is contingent and can be extended and amended to be lengthened, you have the contingency possibly expanding beyond 21 years. And the case on this is the Caruso case. That was an option agreement, an option to purchase a home. And the triggering event dealt with third-party mortgages. And the court found, well, look, those mortgages can be extended. They can be amended and extended beyond their original term. And because of that, the contingency that triggers the option could expand beyond 21 years. And therefore, the rule against perpetuities is implicated and the option is void. So you're going to hear a lot of arguments from the plaintiffs that somehow you should incorporate the 20-year term of the AMI into this definition of project payout. From a plain language perspective, that doesn't work. But even if they were right, because the parties, separate parties, the parties to the AMI, because LOPCO left and was no longer a party to the AMI, could amend that to extend it past its 20-year term, you still have a failure under the rule against perpetuities. And I think the defendants understand that, because really what they do is make a bunch of other arguments to try to save the back end under the rule against perpetuities. In fact, they filed an amended response a few weeks ago that raised for the very first time their first defense, which is their argument is rule against perpetuities doesn't apply to contracts, doesn't apply to contract claims. And because we've pled this as a contract claim, the rule against perpetuities doesn't apply. And they cite this language that I put up from the Supreme Court decision in Yao. And it just doesn't get them there. It doesn't get them there because it doesn't say what they want it to say. This was the Supreme Court dealing with an option agreement, an agreement for an overrides in future interests, just like this case. And one of the parties, Granite Party, argued, well, no, that was merely a contract right. So the court dealt with what they called the preliminary question. And they said, look, and what they cited was black letter law. If the Yaos have merely a contract right, the rule doesn't apply. But if the Yaos interest is also a property right, the rule can apply. That's not surprising because that's black letter law, Your Honor. Here's texture from October of 2020 that lays that exact same rule out using different language. The rule against perpetuities does not affect contracts that do not create rights of property. That's why we don't have rule against perpetuity defenses in indemnity agreements, personal service contracts. That's obvious. If a contract creates an interest in property that equity can enforce, however, then the rule against perpetuities applies. And that's what we have here. We have an option, a contractual option, that creates an interest in property, meaning a working interest, a back-end working interest in a mineral estate. That's a classic contract creating a property interest. And they cite, Mithril cites to the Course-View case out of the Galveston Supreme Court to support their position. It doesn't get them there. First, that decision in 1953, the language they cite to is dicta. The very first thing the court determined was that the parties had waived the rule against perpetuities. But all the court found in that case is that particular contract did not create a property interest. But there have been numerous other cases that have found that contracts like this create property interest. The Caruso case is a good example. That's an option agreement. That was a breach of contract claim dealing with an option to purchase a house, and the court found an affirmed summary judgment on the rule against perpetuities. Maupin and Garzon are both option cases, options to acquire mineral interests that the courts found violated the rule against perpetuities. The Yao case out of the Supreme Court dealt with an override right in future acquired leases. And the Supreme Court found that that contract right violated the rule against perpetuities. We were a little surprised. I've got to tell you, I was a little surprised. I think my whole team was surprised when Mithril raised this contract claim argument for the first time in their amended response, because it's entirely inconsistent with everything that they've claimed over the past 2 years. They have stood up before this court, both in pleadings and in oral argument, and have told you that they have a property interest in the back-end claim, that they have record title to the back-end claim. You look at their original response to the very first motion for summary judgment we filed on the rule against perpetuities. And they talk about a reversionary interest, our future property interests, and the LOPCO back-end is a reversionary interest, a property interest. They filed Cosgrove supplemental briefing telling you that they had record title in the LOPCO back-end, not a contractual right, record ownership of the back-end. And they filed a response to our motion for summary judgment on estoppel, waiver, and ratification, where they explicitly called the LOPCO back-end property rights that they had an interest in. And they were right that the LOPCO back-end is a contract that creates a property interest because it gives them an option to acquire a working interest in a mineral estate, both existing leases and future leases, exactly what the Yale court found to be governed by the rule against perpetuities. So what's their next argument? Their next argument is quasi-estoppel. We should be estopped from asserting the rule against perpetuities. And that has a number of problems, but I'll highlight two of them. The first, which is not on the slide, is that fails as a matter of law. Quasi-estoppel is a defensive measure. Quasi-estoppel cannot be used to create liabilities or create rights that do not exist. That's the Huruska case out of the Texas Supreme Court that's cited in our briefs. And that's exactly how they want to use quasi-estoppel. Why? Because the rule against perpetuities, when it's violated, makes an interest void at its inception. It never existed. and they cannot use equitable estoppel to create a right that doesn't exist. That fails as a matter of law. The second problem is for quasi estoppel, you need to have an inconsistent position that's been taken. We've never taken a position that the Mithril, now the Mithril, the LOPCO backend did not violate the rule against perpetuities. They try to get there by arguing that the defendants honored in an agreement, with Compass, honored the backend. And because somehow the Compass backend is similar to the Mithril backend, that's taking a position on the rule against perpetuities. Putting aside that there was never a position taken on the rule against perpetuities with the Compass backend, that's in a different agreement and has materially different language than the Mithril backend. The AMI is the contract that creates the Compass backend, and it has an expiration clause, which the LOPCO backend does not. And like any other contract, when the contract expires, your rights go away under the contract. Because there was an expiration clause, think about it. If I have the right to be paid $50 a month, each month, and the contract says it expires at the end of this year, when the contract expires, so too does my right to get paid $50 each month. The Compass backend is an obligation by one counterparty to give Compass a backend. If the backend is not triggered before expiration, that right goes away, unless there's a savings clause. You see it all the time in contracts. Clauses say these particular provisions will survive expiration, and that doesn't exist in the AMI. So they're different agreements with different language. So even if you could somehow argue that by resolving a dispute with Compass and honoring their back end to resolve that dispute, we somehow took a position on the Compass back end and the rule against perpetuities, that doesn't get you to quasi estoppel as to the Mithril back end, the LOPCO back end, which has different language in a different agreement. They have two more arguments. I'm not going to address their public policy argument. Public policy is for the Texas Supreme Court to decide, and we've briefed why their public policy arguments are incorrect. They argue that the section 5.043 of the Texas Property Code requires this court to reform the LOPCO backend. They're wrong about that. They're wrong about that because of the plain language of the statute. The statute, the reformation provision, applies to legal and equitable interests that are conveyed by an inter vivos instrument or will. We're not talking about wills. We're talking about inter vivos instruments here. And here there was no conveyance. There's an option, and if the option's triggered, then there would be a future conveyance of the working interest. But the option is not a conveyance. And that was dealt with again in the Caruso case. That was an option agreement like this one. And the plaintiff in that case argued that they were entitled to reformation under 5.043, and the court held they were not, because 5.043 by its plain and ordinary language requires a conveyance, an assignment, a deed, something, some attempt at a conveyance that fails because of the rule against perpetuities, which does not exist when you have an option. The conveyance hasn't happened yet. So they're not entitled to reformation under 5.043. So at the end of the day, Your Honor, like I said, there's been a lot of ink spilled. There's going to be a lot of complexity. This is, I think, a very straightforward application of the rule against perpetuities. You have an option to mineral interests. That's a property interest. The contingency is a financial calculation about when you have break even without an expiration date. It is possible for that break even date to take place more than 21 years after the contract was signed. And as a result, it's void under the rule against perpetuities.
All right, and if you stop sharing at this point, thanks. All right, and for the plaintiffs?
Afternoon, Your Honor. Spencer Cox on behalf of the plaintiffs.
Go ahead.
I will also share my screen. Slide here. And Your Honor, before I get into the meat of the argument, I would like to address one thing directly. And let me ask, are you able to see my screen? I'm getting a...
Yes.
You can't see it?
Yes, used to, you could tell what you were sharing, but now you can't.
Right. I'm getting a notice that says sharing is paused, but if you can see it, I'll proceed. I want to go right to one thing before we go back to the beginning. One of the arguments that's at issue is whether the definition of project payout is dependent upon the existence of the AMI agreement. Specifically, if the AMI agreement exists at 20 years, does that also terminate project payout? And one of the arguments made is that the participation agreements don't incorporate the AMI agreement, they merely refer to it. This language right here, the sentence directly before the sentence that creates the Lundberg backend.
All right, Mr. Cox, actually, at this point, all I can see is it says Spencer Cox has started screen sharing, but apart from that, it's a black screen.
Let me stop and then see if I can't restart the share screen. How about that?
That's better.
Okay. Great. So the argument was made, Your Honor, that the participation agreements merely refer to the AMI agreement and they don't incorporate its terms. I won't try to find the slide. You might want to highlight it with my, right here with the mouse. Here we have the sentence that creates the LOPCO backend at project payout, which is defined herein. Immediately before that, if you read starting with the participant absolutely accepts and agrees to be bound by all of the terms and provisions of the AMI agreement. It clearly incorporates the AMI agreement, including the 20-year term. So with that in mind, Your Honor, we'll work back from the beginning here. There are a number of reasons why the LOPCO backend is not void under the rule against perpetuities. The first, as counsel alluded to, is the Yal case. And there was expressed surprise that we made an argument for the first time based on Yal. Yal came out in May of 2020. That was after perpetuities motion had been pulled down for the second time and before it was refiled for the third time here. So there was probably some equal surprise on this end that Yal wasn't addressed at all in the defendant's opening motion. Well, this is awful. Let me attempt to reshare with you and we'll get going. Here are 5 independent reasons, Your Honor, why this motion should be denied. First, the LOPCO backend has a dual nature as both a property and a contract right. The contract right and the contract claims per Yal, the recent Yal decision, are not subject to the rule, only the property claims. Second, to the extent that any claim is implicated by the rule, it passes the rules test because project payout, which is a triggering event, either has to happen within 20 years or it doesn't happen at all. Third, to the extent that there's any doubt, and there shouldn't be, the court is required under law to accept any reasonable construction that validates the backend. Fourth, notwithstanding that, if nevertheless an instrument still violates the rule, it's required to be reformed. Required is a judicial mandate to reform the rule consistent with the creator's intent so that it's valid. And lastly, there is a public policy argument that we will address and why this court should consider it. These are quotes from the Yal case. As you can see, it was issued on May 15th, 2020. A right can be a contractual right, a property right, or both. The LOPCO backend is both, and it's well established that the rule only applies to property rights. The Yals have a property interest, but in the footnote, we also recognize that they have a contract right. The two are not mutually exclusive. Now, I understand the defendant's argument to be that if there is a property interest involved, then the rule applies to the entirety of any possible claim that might be implicated. But that's not how YAL reads. YAL time and over again indicates that the rights and the claims are to be evaluated separately. For instance, just one example, at one point in the YAL decision on page 5, discussing a basic rule of contract interpretation, and they list the principle, parties are free, as you can see. Then the court writes, although this principle may have aided the YALs in a claim for breach of contract, they chose not to pursue such a claim in this court. Now, granted, the YALs didn't bring a claim for contract, so the question wasn't directly before the court. But if the court views the rights as all bound up together and the rule applicable to all of it, then this sentence, this digression, makes no sense. All throughout the YAL decision, it clearly draws a distinction between the contract right and the contract claim, and the property right and the property claim. And the rule against perpetuities only applies to the latter. Moving on, I think, to address where defendants spent much of their focus is the 20-year term of the AMI agreement, which is the 20-year term for project payout, which means that the triggering event must happen either within 20 years or it can never happen at all. And that passes the test of the rule. Here is the language that creates the back end. I know we've looked at it once before. It's defined herein to have the same meaning as defined in the AMI agreement. Now, defendant's interpretation is that the parties to this agreement simply borrowed the language from the AMI agreement, cut and paste that language here in a shorthand, but had no intention and with absolutely no of either incorporating or tethering or attaching project payout to the project that is actually going to pay out. Their interpretation is that this financial event is wholly untethered from the actual project itself. And of course, we think that's nonsense. It's project payout. It's, as counsel stated, the break-even point for the project. No project, no payout. The AMI agreement in paragraph 6 terminates no later than 20 years from signing. That's when the project ends. The original agreement is dated September 24th, 2001. Participation agreements happened shortly thereafter. It's all part of this transaction. All right. 20 years from the first, the AMI terminates. Project payout will have either happened or it will never happen. The interest will either vest, if at all, well within the 21-year requirement of the rule. What else is in the AMI agreement that helps? Well, this is the formal definition of payout. Everything that is either bolded or underlined is a defined term in the AMI agreement. Payout is calculated based on lands, existing leases, interest, amendments, overriding royalties, and gathering system. It even then refers back to a letter agreement dated December 2nd, which is just one more of the agreements that make up this transaction. The purchase price for the project, interest amendments, and the planned gathering system. All of the definition of project payout is wrapped up in the AMI defined terms and the project itself. Furthermore, the AMI agreement is where we have the obligations for creating payout statements, regular quarterly accountings. The operator has to track that, has to keep everyone up to date on where we stand on payout. When payout occurs, the operator is going to give notice to the appropriate parties. It's got to be written, et cetera, et cetera. These kinds of details about who's tracking what and what happens at payout aren't included in the participation agreements because they've already been incorporated by the parties' agreement to be bound and accept all of the terms of the AMI agreement. The participation agreements have other ties to the AMI agreement. They list it as number 1 as Exhibit B to the PSA. It lists all the other deal docs that make up this transaction. And then there's an express incorporation. Another bridge between the participation agreements and the AMI agreement that ties all of these concepts together is the September 25th, 2001 letter of understanding. September 25th was the day after the September 24th purchase and sale agreement. And it's the purchase and sale agreement to which the AMI agreement is an exhibit. So one day after the original PSA, parties enter into this letter agreement to make a few things clear. One of the things that they want to make clear is that the Compass backend is tied to the LOPCO backend. Whatever LOPCO acquires or is able to negotiate for itself with its participants, the Compass backend is going to be half of that. And Compass President Cadell Licky's testimony confirms that. But whatever LOPCO gets, Compass is going to take half. And so what this letter agreement does is says, look, let's just make that clear. The AMI agreement says 12.5%. But if that ends up being, if LOPCO's ends up being different than 25, we're going to adjust ours to be half. The two are tied together. As the participation agreement itself notes, the LOPCO after project payout interest is going to absorb the Compass agreement. Just as a side, this is how the project works. On the left, we've got 100% of the working interest, and then the gray is LOPCO's back end. If project payout occurs, the LOPCO back end happens, that piece comes out, and then LOPCO and Compass effectively will split it, with each getting half. That's why Compass is 12.5% and LOPCO is 25, because once you subtract it out, they've both got an equal 1/8. Defendant's interpretation ignores everything we know about the context of this transaction. To look at a definition of project payout as if it's just wholly untethered and in isolation from the larger project itself ignores, first of all, that the parties to the agreement directly agreed to accept and be bound by the terms of the AMI, and ignores all the other context showing the participation agreements were just one of several of these documents that made up the project, the deal documents for the project. The interpretation that this project payout is a different project payout that is free floating and off on its own is just wholly disengaged from the reality of the deal. It's a litigation argument, and it's not an interpretation that any party to the agreement itself understood at the time. Project payout is payout for the project. If there is no project, there is no project payout. And if there's no project payout, there can be no LOPCO backend. That's why the backend is limited to the 20-year term, and it easily passes the rules test.
And the argument about whether the AMI could be extended without the LOPCO interest's consent?
Yes, Your Honor, thank you. You anticipated my very next slide. I think that is handled rather straightforwardly. This quote is from the LADEX case, but there's any other number of cases that could have been listed here that say the same thing. When you're looking, when you're evaluating an instrument under the rule against perpetuities, you look at the conveyance as of the date, the date that the instrument is executed. So on the date that the participation agreements were executed, the AMI agreement had a 20-year term. Now, later on, can the parties do something else with the AMI agreement? I think that's a wholly different question, but it doesn't affect the analysis under the rule, which is what did the AMI agreement look like on December 19th when the participation agreements were executed? I do want to address the Caruso case. And I think the best way, which is on this same point about extending it can never happen. I think the best way to do that is to just pull the case up itself, and I will share a PDF of that case with you. This is, you see at the top, Caruso v. Young. It came out about a year, almost a year exactly before the Yao case. On the right, we have the factual background, and it's talking about the option. The reason this failed the perpetuities test under Caruso is that this was a lease that was automatically renewable every year. As the court describes it, it was a perpetual lease. It never terminated unless someone took affirmative action. The option that's at issue is an option that lasts for as long as the lease is in effect and the lessee is not in arrears by 1 month and not in violation of performance. There is the mortgage balance comes into play in this case because that's the price to be paid for the option. The mortgage balance has nothing to do with when the option either terminates or expires.
Okay.
So that, Your Honor, is how project payout being tied to the project is the correct construction. We think it's the only correct construction of project payout as the triggering event for the LOPCO backend. But to the extent that there's any doubt, and there should not be, but if there is, the Texas Supreme Court has made clear that if there's a reasonable construction that validates the backend, the court must accept it. And we do that because we assume that the grantor intends to create a legal instrument rather than one which is illegal. Okay. So I will pause there to make a chapter break of sorts. The instrument passes the rule against perpetuities. At most, it passes because it has a termination that's 20 years, which is well within the 20-year requirement of the rule. But nevertheless, if the court were to find that the instrument violated the rule, Section 5.043 of the Property Code requires that it be reformed. It's a judicial mandate and applies to commercial instruments creating property interest that violate the rule. This is again from the Yal case that was just issued. The Yal case considered the exact argument that there was a limitation on what the statute applied to. And first of all, it notes that in Section A, it applies to an interest in real or personal property. The court shall liberally construe and apply this provision to validate those interests consistent with the creator's content. This is the section that defendants cite in their brief. It's also the section that the Caruso case cited as the basis for limiting the scope of what kind of instruments the statute applies to. The Yal court, again, the Texas Supreme Court, in May, responded directly to that section. At subsection D, it instructs you that the statute is to be applied prospectively. It is not a scope limitation on the types of instruments it covers. As the court noted, we saw earlier, it applies to commercial interests, create interest in property. It requires to be liberally construed. The Yal court went on, you have to reject any strained or narrow construction of the statute that would hold otherwise. So here is a requirement. If the instrument does violate the rule and it may be reformed, the court shall reform it. Okay. In this case, we don't think it violates the rule, but if it did, it easily could be reformed to make clear the party's intent that the back end, both back ends, are congruent with and symmetrical with the project. That if there is no project, there is no project payout, vice versa. There is no back end if there is no project. It makes eminent sense, and it's reflected, frankly, in all of the ties between the participation agreement, the AMI agreement, and the other transaction documents. But to the extent that it needs to be made more clear, this section 5.043 requires reformation in that case because it would be consistent with the creator's intent. As to the public policy, I know the defendants asked the court pass on public policy and that the Texas Supreme Court decide what public policy is, which I agree with the latter. The Texas Supreme Court does decide what public policy is. They make that decision and then they provide that decision to lower courts so that lower courts can execute and follow the law consistent with that policy. The purpose here, the policy is not to void interest when they violate the purposes of the rule. The purpose of the rule is to prevent landowners from using remote contingencies to tie land up so that it can't be bought and sold or transacted in the market. There are any number of commentators, treatises, cases explaining how perpetuities concerns are not implicated in the oil and gas context. This is just one quote from the Koopman case. And here's why. This case is a perfect example. Notwithstanding the Compass back end and the LOPCO back end, Compass sold this project to LOPCO, who put it together and sold it to the participants. The participants then sold it to an intermediary, who then sold to Blackbrush, who then sold to Intervest, who then sold to Magnolia. All of these transactions subject to one or more backends. There is no, the backends provide no constraint on alienability, don't affect it at all, as shown by the history of these very assets. And we think that's yet one more reason why the LOPCO backend should not be found to violate the rule. So having gone through the presentation, I'll just reiterate and respond to a few points I think that need to be made. Again, project payout is payout for the project. Now, there was some argument as to Mr. Kasman's testimony. Mr. Kasman is plaintiff's expert on reservoir engineering. He's also offered as an expert on AMI agreements. He was testifying as to the scope of the backend. In other words, what part of the assets does it reach or not reach? But when he was in the passages that were shown to you, he was testifying based on his knowledge as a participant. His participant in this transaction that was 20 years ago. All of the questions that were directed at him were, how big is the backend? How far does it extend to interest? Does it extend to other leases beyond just the original leases? The answer is yes, but what matters is that was the concept. In that context, it's not to be expected that Mr. Kasman would recall from 20 years ago that the AMI agreement has a 20-year term, or to know the implications for that on the rule against perpetuities. Simply, no one is going to be an expert on the application of perpetuities. His point was simply to agree that if you add more cost, payout is going to take longer. And that is not a controversial statement. As to the issue of estoppel, it's this. Quasi-estoppel does not require a party to say the exact same words, but in the negative, to be estopped from later taking an inconsistent position. We looked at the relationship between the Compass backend and the LOPCO backend. Recall there's the letter agreement that shows that the Compass backend is equal to half of the LOPCO backend. Nevertheless, defendants all agreed for their mutual benefit to honor the Compass backend and validate it with respect to what they call the future interest. Now, that could only be possible if the LOPCO backend was valid as to future interest, because if the LOPCO backend is nothing with respect to those interests, then the Compass backend must be half of nothing. The two cannot exist, they're inconsistent. That's why they're stopped from reversing now and saying the parent interest is void. Unless you have further questions for me, I'll take a seat and wait to see if there's anything else I need to respond to. But I believe that that gives you the various, in many reasons, we think why this backend should be upheld.
So how would the interest, the LOPCO backend be revised to make it not violate the rule against perpetuities if it does?
Yeah, how would you reform it, Your Honor?
Yes.
I think that would be pretty simple. You could do it in a number of ways. For instance, you could say at project payout, which must occur within 20 years of the date of the AMI agreement. You could insert a qualifier that the LOPCO after payout interest is itself terminates 20 years after the AMI agreement, or you could insert a qualifier that the LOPCO backend after payout interest is only valid to the extent that the project continues. Either one of those, I think, would capture the creator's intent that the LOPCO backend and all of the backends are congruent with and holistic with the project itself.
All right, thank you.
Your Honor, if I may,
Yes.
I'm going to share the screen very quickly. If you'll give me one moment, there we go. Let's see if this works. All right, Your Honor. Oh, it says I'm not sharing it. Let's try that again. Sorry about that, Your Honor.
Yeah, it's acting strange this afternoon.
Amir, watch out. You had your chat up as well. Just don't show that.
Sorry about that. There we go. Hey, can you see that, Your Honor?
Yes.
Okay. Your Honor, I'm going to go through each of the arguments, but I want to start with what Mr. Cox started with because it's important. He showed you a portion of the participation agreement very quickly to tell you that the participants agreed to be bound by all the terms of the provisions of the AMI agreement, to try to make the argument that in the participation agreement, the parties contractually incorporated the terms of the AMI agreement. That's not what that clause says. If you look at it, it's in dealing with assignments, and I've highlighted the relevant language. It talks about an assignment from Lundberg to the participants. Such assignment shall be made subject to certain terms and shall provide that one participant assumes its proportionate share and that the participant absolutely accepts and agrees to be bound by all the terms and provisions of the AMI agreement. That is different than what they're trying to argue, Your Honor. There's no doubt that there was a contractual obligation in the participation agreement that when there was an assignment of interests from Mr. Lundberg to the participants, that assignment would bind the participants to be bound by the AMI because there was a contractual obligation between Compass and LOPCO that LOPCO do that. That's far different than saying that this contract incorporates the terms of the AMI, which is what they'd like you to rule. And the law is clear that you cannot imply incorporation. The Neville case, and I'll give you a cite because it's not cited in our brief, 2013 Westlaw 124591 at star 2. That's a federal decision. The Trico Marine case, 73 Southwest 3D 545 550. That's out of the Houston Court of Appeals. And I know I'm speaking quickly, so I'll let you write these down. The Valero marketing case, another federal case, 2010 Westlaw 106 8105 star 5. And we've cited another case in our brief. Stand for the unremarkable and well-established position that you cannot imply incorporation of terms. That for there to be an incorporation for the participation agreement to incorporate the term of the AMI, it must be plain, it must be clear, it must be express. It cannot be implied. And you don't have that incorporation of the AMI. That's why they showed you this language quickly, because this is talking about what the assignments, because remember, there was an assignment from Compass to LOPCO that was subject to the AMI, and LOPCO and Compass knew that LOPCO was going to then reassign those interests to investors. And so that assignment was going to make the investors' ownership of that mineral interest subject to the AMI because they had to participate in the AMI. That's different than suggesting that this language incorporates the term of the AMI. What they're trying to have you do is imply and rewrite the project payout language that's in the participation agreement. The participation agreement says project payout is the same definition as what's in the AMI. And that definition is in paragraph 7 that I showed you. I'll show you page 11. It doesn't have a term. So what Mr. Cox showed you is, well, there was this letter agreement. There's this letter agreement between Compass and LOPCO that talks about the interrelationship between the Compass back end and the Lundberg back end. Yes, they were related. Compass gave LOPCO permission because they needed Compass's permission to negotiate a back end for itself as well as the Compass backend. He says, well, there's this language talking about, let me find it, language talking about the LOPCO backend will absorb project payout reserved to Compass. That's this language at the bottom highlighting. All that says is that this LOPCO backend of 25% is not 25% plus 12.5%. That is, if we earn our back end and Compass earns their back end, the maximum back end will be 25%. This doesn't say anything about incorporating the term of the AMI. It is quite possible that the Compass back end would have expired under the AMI, never been earned, and project payout would have occurred later. Under those circumstances, LOPCO would have earned a 25% back end and would not have had to share in it, would not have to absorb the Compass back end. This language is making clear that it's 25% max. 25% either goes all to LOPCO or 25%, and if Compass earns their back end, the LOPCO back end is going to absorb that 12.5%. We don't have to pay 37.5%. These are all this showing you agreements and talking about the interrelationship when the parties were negotiating. That's all an attempt to imply a term that doesn't exist, because they can't win on the plain language. If you look at the plain language, project payout, which is defined herein to have the same meaning as defined in the AMI. They could have said project payout, which is defined to occur only if a project payout under the AMI occurs during the term of the AMI or something to that effect. They didn't say that. They just said, just look at the definition. And if you look at the definition, and I keep losing it, I'll find it for you. If you look at the definition, it does not have a time limit. Project payout at the bottom is the date where you have equality between cost and revenue and net revenue. That's it. Plain language of the agreement. They don't have a way to incorporate the 20-year term. And even if they did, what you do, and Mr. Cox is right about the law, rule against perpetuities, you look at the contract at the time it was entered into. The contract at issue is the participation agreement. And you ask, is there any contingency at that time, any possible contingency by which you could go past 21 years? And one of the possible contingencies, even if you tied project payout to the term of the AMI that existed at the time, was the possibility of amending the AMI. That was a possible contingency. And that's what the Caruso case in footnote 4 talks about, when it talks about the mortgages could have been amended or renewed to go outside the term of the perpetuities. So then we get to YAL, Your Honor. Let me stop sharing these. I don't think you're going to need that. On YAL, what they tell you is look at this quote from YAL on star 5 of the decision, where it says, well, that might have helped them in a contract claim. That means that YAL stands for the proposition that the rule doesn't apply to a contract claim, but it applies to a property claim. So their position is this: if someone files a breach of contract claim and someone files a counterclaim to quiet title, saying your contract claim is creating a cloud on my title, the rule of perpetuities applies to the quiet title claim because it's not a contract claim, but not to the contract claim. So the defendant could win on their quiet title claim under the rule against perpetuities, find the contract to be invalid, but the contract claim would not go away, and the plaintiff could then prevail on their contract claim. That's illogical. That's illogical. That's not what the Supreme Court said. The language, once again, that they quoted from YAL was talking about an ambiguity argument. An ambiguity argument. They were arguing that the contract may have been ambiguous as to what types of leases would be contained. They said that would have helped you on a breach of contract claim, but not on this claim. And all you have to do is look to Caruso. Caruso is a breach of contract claim in 2019 where the court found that the contract claim was barred by the rule against perpetuities. So then we get to the argument that they raise about reformation. And they tell you this issue on reformation, the conveyance language that I pointed to in the statute, was resolved by YAL. They're wrong about that. In Yao, the parties took the position that the language of the statute says inter vivos instrument. Inter vivos means within a life, and one of the parties was a corporation. And so the parties took the position that a corporation cannot issue an inter vivos instrument, therefore they're outside the statute. And the court said that's not true. It applies to corporate transactions as well as to personal transactions. The Supreme Court didn't talk about the concept of a conveyance being required because it wasn't an issue in Yao. In Yao, you had an overriding royalty interest. That's a conveyance. That's a conveyance. The plain language of the statute is that you have to have an attempted conveyance before you can have reformation. And an option which calls for a later conveyance is not an attempted conveyance, and you can't reform the agreement. So then they run away from Casman, right? He's one of the participants, right? He's their expert on the participation agreements. And he testified, he and Mr. Lundberg, their intent was that under the participation agreement, project payout would happen whenever it happened. 10 years, 15 years, 20 years. And that's cited and quoted in our brief. So at the end of the day, you have an option and you have to ask yourself, could it take, is there any contingency where that option could vest outside of 21 years? And that option defines the contingency very, very clearly. There's no ambiguity. There is no competing definition to choose from. The cases that they cite about competing definitions, you pick the interpretation that saves the contract from the rule. That's dealing with reasonable interpretations, ambiguity. There's no ambiguity here. They define the trigger date as a financial transaction, and everyone knows, Mr. Casman knows, common sense tells you that you could have expenses and lease acquisitions, hundreds of millions of dollars of lease acquisitions in this case, that could take you outside the 21-year period. So they fall back on public policy. I won't make a comment about public policy, but I will tell you that the Supreme Court on this issue has already spoken. On this very issue, Yao was a right to a mineral interest on future interests, an option. And the Supreme Court, in an oil and gas context, declined on public policy grounds to find that it didn't violate the rule against perpetuities, and found that it did. So you don't have to speculate about what the Supreme Court will say. You know what they'll say. They'll say in an oil and gas context, dealing with future leases, that implicates the policy concerns of the rule against perpetuities. The Koopman case, that was a different case. The Koopman case was a non-alienable right that would vest with certainty, and the court found in that unique situation, public policy did not support application against the rule against perpetuities. And they say, well, look, there's no alienability problem here. They've sold this project multiple times. That ignores all the evidence that many of the defendants in this case thought there was no lock-go back-in. But it doesn't matter, because when you make a public policy pronouncement, Your Honor, you make it for all cases. And the Yale court decided that public policy does not take this type of case outside the rule against perpetuities. This is a straightforward application. They could have written the option agreement a different way. They didn't. They made it unlimited in time, and it's void. Thank you, Your Honor.
All right. Anything very briefly, Mr. Cox?
Yes, Your Honor, just very briefly. So we can stare at the language of the participation agreements all day if defendants think that we went through it too fast in an attempt to mislead. There is no implication necessary. The parties expressly agreed to accept and be bound by the terms of the AMI agreement. The argument is that that only applied to a piece of the deal that was made in the participation agreements. But that makes no sense in context as to why only one little part of the agreement over here is going to be wrapped up with the AMI agreement and its terms and conditions, but not the piece of the agreement that shows up in the very next sentence. The proper, correct construction in context is that the back end subject to the project being in existence, and it had to terminate or have occurred within 20 years. You asked me to be brief, Your Honor, so I think I'll.
Okay, thank you. Next is a motion for partial summary judgment on lack of title. Did I write that down correctly?
Yes, Your Honor, and Mr. Freeman, also Mr. Olive's co-counsel and counsel for defendant Magnolia will present argument on behalf of the defendants on that motion.
Yes, Your Honor, I'm ready if you are.
All right, I'm trying to find. Here we are. Okay, lack of title. Okay, go ahead, sir.
Thank you, and I'm going to share my screen if that's all right.
Yes.
All right, can you see that, Your Honor?
Yes.
Okay, great. So, Your Honor, the prior motion and a few of our motions in earlier hearings focused on some of the reasons that Mithrail's claims to the LOPCO backend fail, even if, as Mithrail claims, Mr. Charles Lombard, who is the owner of LOPCO and then subsequently created Mithrail, transferred the LOPCO backend when he transferred virtually all of LOPCO's assets to Mithrail in September 2002. That's the basis of Mithrail's claim to the backend, is those transfers that Mr. Lombard filed in September 2002. So all of the prior motions have assumed that there was a valid transfer of the backend from LOPCO to Mithrail at that point. So this motion deals with the fundamental issue of whether at that time when Mr. Lombard filed assignments trying to transfer LOPCO's assets to Mithrail, whether LOPCO had a backend at that point to give to Mithrail, whether it had title to a backend interest. And as it turns out, the answer is no. And as a result, it is a very straightforward application of the law to say that because Mithrail, who is the plaintiff in this case, LOPCO no longer exists, did not receive a backend from LOPCO in September 2002, that it does not have a claim to a backend. And I'll walk through the basis for that. But first, to take a step back, the basis for Mithrail's claims in this case, and they arose mid-lawsuit in early 2018, is Mithrail has claimed that it has record title to the LOPCO backend. These on the screen are some excerpts from the brief right before we filed the lack of title. This is the plaintiff's supplemental brief on Cosgrove v. Cade, and you can see they're making it abundantly clear that the basis of their claim is that Mithrail holds record title to this backend interest. So as we set out in the motion, and I'm happy to go into it in more detail if I need to, the motion demonstrates that, in fact, when you go back and look at the record title, Mithrail does not have it. And the reason that Mithrail does not have it deals with the assignment that is located on the screen, circled in red, and that's what we're calling the participant assignment. That is the assignment that occurred shortly after the LOPCO and Compass purchase closed. There was an initial assignment from Compass to LOPCO, and that is the assignment up on the top left of the screen. And then the next assignment that happened was the assignment from LOPCO to the participants, and that's what we're calling the participant assignment here. And in that assignment, what LOPCO did is it conveyed 100% of the interest of LOPCO's leasehold interests to the participants, save and except to tranches of interests that aren't at issue here, and it reserved an override. But what LOPCO did not do is reserve a backend interest. And so at that point, that was December 21st, 2001, any back-end right or interest that LOPCO may have had the option to create or created within the, I'm going to call them the letter agreements. They're also called the participation agreements. The only reason I'm going to say letter agreements is so we don't confuse it with the participant assignment. But those 21 letter agreements, any back-end that LOPCO created through those was gone. As a matter of law, LOPCO did not reserve it, it is gone. And so as a result, when LOPCO transferred and Mr. Lundberg filed numerous documents in September of 2002 purporting to move all of LOPCO's assets over to Mithrail, while the override may have been conveyed to Mithrail because LOPCO had an override to give, and you can see that as the arrow moving over into the Mithrail column, there was no back-end that LOPCO had reserved and had in September of 2002 to pass to Mithrail. So as a matter of law, Mithrail does not have the record title that it claims. Now, to Mithrail's credit, or plaintiff's credit, Mithrail does not appear to even dispute this. It is truly indisputable. And so now Mithrail, it appears, has just abandoned their claim to title. However, they have shifted now and reversed to 180 of this is now a contract right. And that's what we're talking about, is really what the LOPCO back-end is a contract right that is created in the participation agreements. And so that's why it didn't pass. That Mithrail makes 6 different arguments in the response. I'll go through these in a moment, but all of these arguments do not address the actual issue, which is that the participation assignment by its terms, and is not in dispute, conveyed any back-end that LOPCO had. So all of these arguments do not touch that point, and because the reason for that is because it's untouchable. That is what the assignment did. So the first argument Mithrail makes is that, well, as I mentioned, the LOPCO back-end, it's actually just an enforceable contract right. But again, that does, simply calling something a contract right after calling it a property interest does not mean that all of a sudden you've created a new reservation via semantics. What matters is what the scope of the conveyance was in the participant assignment, the actual assignment that was filed of record. These letter agreements were previous agreements that were not filed, and whether that included, as a matter of law, the LOPCO backend. Now, again, we have set this forward in our motion and explained it, and I'm happy to go through it. But in sum, the LOPCO assignment to the participants conveyed all 100% collectively of LOPCO's interests and into the existing leases, it was the leases in existence at the time, and all other rights, titles, and interests that LOPCO received both under and by virtue of the Compass assignment. And LOPCO also unequivocally, while they did reserve an override in that conveyance, it did not reserve or accept a backend for itself. And Mithrail's response, it's sort of buried near the tail end, does not dispute this. There is no dispute that that is the scope by its terms, by the 4 corners of that assignment of the LOPCO conveyance to the participants. So again, the argument that is being asserted in the response is that it is an enforceable contractual right, and so that is why it survives the conveyance. But that is not the law. There is no case that says, oh, well, since you're saying it's only a contract right now, then okay, it wasn't subsumed within the conveyance. Instead, conveyances, because a grantor is the master of its own interests, they're presumed to have conveyed the greatest estate that is possible under those terms. And that includes all rights, remedies, and benefits incidental to the property that is being assigned. And the property that is being assigned in this case is the existing leases, and the rights, remedies, benefits that are incidental to that would be a back-end right to the working interest. And again, there was no reservation in the participant assignment of a back-end. In fact, the participation assignment was not even made subject to the letter agreements. It was made subject to other agreements, specifically not the letter agreements. It did not even mention the letter agreements. And so accordingly, because of that, the standard is that all of LOPCO's interest, 100%, moved over to the participants except for the express exceptions and reservations in the document. Now, again, we've talked about that it's been previously asserted for 2 years in this case that the Mithril's claim is a property interest. But it is also, that's how it's pled in this case. Mithril's claims that have been pled in this case are property claims. It does not matter the form that they put them in. It does not matter that they have styled them in breach of contract. It is still, at essence, a property claim. And these are the claims that we are asking the court to dismiss for lack of title because they are based in property. In fact, I know you just heard in the last motion an argument to reform the LOPCO backend based on the Texas Property Code. They are clearly property claims. The next two arguments that Mithril raises in its response is that the merger doctrine does not apply, and that's the doctrine that says, well, terms of a prior conveyance are, once a deed is executed, terms in a prior contract for sale are merged into the deed and no longer exist. The argument is that doesn't apply here because the LOPCO backend is collateral to the conveyance, and also the merger doctrine does not apply based on the agreements and the assignment being close in time. Once we received this response, we did a search of our motion for the word merger, and it's not there. And the reason for that is because we don't need the merger doctrine in this case, because it's not about whether something that wouldn't ordinarily, that wasn't expressly within the conveyance is now gone, whether there was some other term in the agreement is now gone. The point is that it was conveyed, it was assigned, the LOPCO backend was within the conveyance. So it's not merely a matter of merger, it is a matter of, by the terms of the agreement, the LOPCO backend was assigned and not reserved. Now, because it's now been brought up, I do feel compelled to point out that the LOPCO backend by its terms is not within the collateral rights exception to the merger doctrine. These listed on the screen here is some examples of collateral rights, including the cases cited by Mithril as to for the exceptions to the merger rule. These are things that don't deal with the scope of rights and interests that are conveyed. So it would be escrow terms, arbitration provisions, indemnity obligations, attorney's fees provisions. These are truly collateral rights. But when it is the conveyance provisions, and when it's provisions talking about the conveyance itself, in fact, I know you saw it in the last motion, the LOPCO backend is within the same paragraph that is talking about the assignment from LOPCO to the participants. The Supreme Court of Texas has recognized that those provisions are not collateral because the conveyance is not silent to them. The conveyance actually speaks directly about the scope of interest conveyed. And in this case, it is undisputed that the participant assignment conveyed all of LOPCO's interest and did not reserve a backend. So there's a case, I believe it's 1977, by the San Antonio Court of Appeals, Sanchez versus Dickinson, and this is a case that Mithrill's response says is on all fours with our case. And the reason for that is the holding of this case, or one of the holdings, is that there was a right of first refusal, or a ROFR, that was held to be collateral and did not merge into the agreements. And so that's, on that basic point, Mithrill's latched onto that holding and said that this case is on all fours. But when you actually look at what happened in this case, it supports our point on why LOPCO conveyed its option to the participants. So in Sanchez versus Dickinson, there was two separate properties. There was a larger tract of land and then a smaller homestead. And there was a contract between the property owner, Penna, and the potential buyer, Elledge, and that contract gave Elledge two different rights. It gave him the option to buy the larger tract, and then it also gave him a right of first refusal on the homestead. And then after that, Elledge took the option to buy the larger tract, and the larger tract was conveyed by a deed from Penna. And it said nothing about Elledge's right of first refusal that was also in the contract. And ultimately, the court found, okay, well, Elledge, who's the grantee in this situation, did not make the deed. And he has the option on a different set of land, on a different piece of land. That ROFR on the homestead, on property 2, was collateral to Penna's deed for property 1, and so they did not merge. Elledge still had his ROFR on property 2. But what the court also found, because Elledge was not the defendant in this case by this time, is that subsequently, as the land got passed on, when Elledge conveyed still property 1 to the Garzas, and Elledge was the grantor, that Elledge, he had the option, and he then granted land, and the scope of that conveyance included the ROFR, the right of first refusal, that it was conveyed. So the point here is that if a holder of a right conveys its interests, and the right or interest is within the scope of that conveyance, it's gone. It moves to the grantees. And that's what we have in this case, is LOPCO, while it may have had a contractual right or property interest, or however you want to describe it, it conveyed it to the participants expressly and undisputedly in the participant assignment. And so it was conveyed. The cases we have cited, I know the court's familiar with one of them because we had some discussion about it at the last hearing, Cosgrove v. Cade from the Texas Supreme Court, and also a recent case that's actually originally from this court with Judge Saxon, and then went up to the San Antonio Court of Appeals in 2019, Jar-Zombik versus Marathon. These are two cases we have explained in the briefing, and the argument is that they don't support our case and don't support summary judgment here. And frankly, we just disagree. And I'll briefly walk through some of the similarities here. I know Your Honor is familiar with Cosgrove v. Cade. Prior contract allowed the Cades to retain a mineral interest. They conveyed the property, did not retain a mineral interest. The time to reform that conveyance passed. Then the Cades asserted a number of claims trying to claw back that interest, and ultimately the Texas Supreme Court said, well, by its terms, you conveyed the mineral interest. All of your causes of action, including breach of contract, were barred as a matter of law. And without repeating that, that's exactly what we have here, because while Mithrill claimed for 2 years that it had record title, it now admits that it does not. And so the back-end interest was conveyed. All of Mithrill's causes of action based on the back-end interest are barred as a matter of law. Jar-Zombik is particularly on point in this case, because what Jar-Zombik dealt with was actually a contingent future interest. So the plaintiffs in that case had some present interest to land, and they also had from a prior deed a contingent future interest. It was a possibility of reverter to a royalty that had been reserved in others. And what the plaintiffs did in that case was then they conveyed the property to the defendant's predecessor in a way that was, it didn't mention either way the contingent future interest. It was just silent as to that specifically. And however, that conveyance was actually made subject to the 1965 deed that had created the possibility of reverter. And so in that case, the plaintiff said, well, when we put subject to the 1965 deed there, what we meant was we get to keep the possibility of reverter. We only meant to convey our present interest, not our contingent future interest. And this court granted summary judgment, and the San Antonio Court of Appeals affirmed, and they repeated the basic standards of law that say, well, you didn't reserve it with clear language as you are required to. And so in that case, even your subject to argument is not enough, because you can't simply say subject to a prior agreement and then have that imply a reservation. That was not clear. So your contingent future interest passed in the conveyance as a matter of law, even if you say you didn't mean to do that. And this case is almost identical, except for the subject to element of the case, which here, the participant assignment actually was not made subject to the letter agreement, making this case even easier, because it is expressly, there are agreements listed as subject to, and they are the compass agreements generally, not the letter agreements. And so here, because they did not specifically reserve the contingent future option in the working interest, it passed as a matter of law. The last two arguments I'm happy to go into if Mr. Charest goes into them in response, but I know some of this was talked about briefly in connection with the rule against perpetuities motion. The thrust of these arguments is that plaintiff Smithrail is asking the court to now just ignore that it does not have title. They're saying, well, we're either quasi-stopped from pointing out that they don't have title, or we did not plead their lack of title or the merger doctrine as affirmative defenses. Just briefly, it is not an affirmative defense to say that Mithrail does not have the interest that it claims to have and that its claims are based on. That is something Mithrail needs to prove, and it cannot prove. So the bottom line, Your Honor, is that Mithrail does not have the viable backing claim that it is claimed for 2 years. We have looked back, looked at the record, looked at the chains of title. It is not there. There is no tie in chains of title to the interest that passed to the defendants in this case, in which Mithrail has claimed that it got in September of 2002. And so as a result, because Mithrail does not have title to the back end, it has no viable back-end claims. And we would ask for summary judgment, and I'll reserve the remainder of my time for a response.
Go ahead, Mr. Charest.
Trying to find my cursor to unmute. There we go. Thank you. Please the court, Daniel Charest for Mithrail on this motion. To be immediately direct to the first point, Mithrail has admitted nothing like what defendants say we have admitted. I think the briefing probably fell short from the defendants in their motion and our response to what they said, because our understanding of their motion was that by implication of the assignment that the back end was therefore merged in. By implication, it was gone. And now what they're saying in the reply came much more clear. They're saying, no, it was an express assignment. The confusion comes from the fact that there is no express assignment in the assignment that they're talking about. All right, they're saying that on the same day, effectively, that the back-end right was created, that LOBCO also intentionally assigned it out to all the participants. And the reason that's such a surprise and so unclear is because nobody in like the 20 years that this case, that the deal has existed, the many people that have owned interest in this, and all the lawyers up until the day this motion was filed had ever thought that was true. Like nobody. And what you just heard was, oh, we're smart guys. We went back on the record and we ran title, da 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 da. That's number one. It doesn't comport with the facts, the documents, the entire transaction, or anything else. It's also not accurate what they're telling you, okay? So it goes like this. The position cannot be right because number one, the assignment does not support what the argument they're saying. The assignment is, there's nothing expressed in the assignment, and we'll look at it in a second, that says, I, Lopko or Lundberg hereby assign to all of the participants the back end, which would obviously make no sense because in that same exact transaction, separated by a matter of days, all of the participants agreed that Lopko could or Lundberg could reserve the back end. So they're saying, was it, I guess, a big mistake or something, I guess is their argument, or it just doesn't matter. But fundamentally, they're trying to divorce this one piece which is misinterpreted from the entire transaction to say, oh, look at this one thing, which I'm misinterpreting, to throw the entire baby out with the bathwater. So number one, the assignment does not support what the argument that's being advanced. Number two, the context of the entire deal does not support the argument that's being offered. And number three, the testimony, the facts from everybody that was ever involved in this transaction does not support what these lawyers are telling you now. So we'll talk about all three of those things in detail. And fundamentally, this is just revisionist history. And I have to pause on that for a moment. The introduction to the argument was a little bit of a white lie. When it's like, oh, all the prior arguments had assumed that the transfer was valid, but here's the truth, there was never a transfer. The fact is that up until the motion was filed, everyone knew what the facts are, and everyone knew that everybody in the deal understood that the back end had been reserved and had never been transferred away, which is the fundamental point of their argument. So the deal context, the timeline is important here. And I will endeavor to share a screen like everyone else is doing here. If I've done it correctly,
yes,
the level of understanding, perfect. Thank you. I'll try and make it fit. There you go. All right, so the whole notion of this transaction starts with the concept that Lundberg buys an interest subject to a back end and agrees with the person that's selling it to him, I also want to do a back end. And that's reflected in the letter of understanding. No question, no dispute. Lundberg marketed the deal with a back-end interest. The terms of participation expressly established that there would be a back-end interest for anyone that participates in the transaction. So again, as he's out there marketing the deal, he's saying, don't forget, I'll have a back-end interest, and everybody understands that that's the case, and everyone agrees. Further to that, the participation agreements, the actual documents that bind the participants through whom all of these defendants receive their interest, expressly says that there will be a back-end right that Lundberg owns and holds. All right, that when project payout happens, Lundberg will have the right to receive a reassignment from everyone here that is now defendants in Lundberg's favor under this participation agreement, which was carried on to everybody took subject to ultimately this participation agreement. So that's the deal. The deals themselves, the documents that show the deal, and the concept and the context of the transaction all support the existence of this back end. And there's no real dispute that the back end existed. The logical fallacy here that's going on is that at the day that Lundberg and the participants create the back end, they turn around and also assign it back out. And that didn't mean that the construct of the deal does not follow that. Let me try to unshare. Okay. And then we talked about, so that's the context of the transaction. Now the next is the participants, the people that actually were involved in this. There's an affidavit in the record from Lundberg telling the court under oath that, yes, I personally promoted this project to all potential investors, made it clear, and I'll share that, I guess, rather than just reading it, made it clear that they would be taking subject to that back-end interest. There's the excerpts there for the court to see. I, on behalf of Lundberg Operating Company, personally promoted, yada, yada, yada. It was made clear that the LOPCO back-end would apply to all the working interests, et cetera, okay? Mr. Kasman, one of the only two participants that were ever deposed in this case, also agreed. Yes, there was a back-end. It happened through the participation agreement. And you know that no one thought back then that it had been, well, let me say it this way. There's no testimony in the depositions about, did you believe that Lundberg conveyed the back-end interest away? Because that, again, that whole concept had never even come up to the lawyers. They hadn't thought of it yet, but neither then had the actual participants in the transaction. They knew full well that the assignment out, and we'll talk about that in detail in a second, from Lundberg to the participants reserved by reference the back-end agreement. And then you also, that the transaction at writ large, meaning both the assignment and the participation agreements, imposed on the participants the duty to reassign back to Lundberg when payout happened. And that is abundantly clear. So Mr. Kasman twice saying the same thing, everybody knew there's a back end. Mr. Pickens, the defendant's own participant that they like to point to, he said the same thing. He says, is that the participation agreement we were looking at, the very first exhibit today? Okay, talking about the participation agreement. It says in the second sentence, in each participation agreement, Lundberg agreed to sell and convey to the addressee. Do you see that? Yes. And it says subject to a revert and vest, subject to revert and to vest in LLC on the occurrence of project payout. Do you see that? Yes. When it's referring to the interest that's going to revert, what is that referring to? That refers to the 1/8, the 1/8 back-end interest payout that had been retained by Lundberg Operating Company. Next page. When you sign the settlement agreement, well after this conveyance that the defendants are now pointing to as having conveyed to Mr. Pickens the back-end right, when you sign the settlement agreement, who do you think the back-end was going to revert to invest in? Could you rephrase that? When you signed the settlement agreement, which Lundberg entity did you think the back-end was going to revert invest in? And this is the answer that's important for the purposes of this particular motion. At the time I signed this agreement, again, the settlement agreement, well after this assignment that these clever lawyers think assigned the back-end, he says, I thought that the Lundberg Operating Company owned the back-end after payout interest, the right to the back-end after payout. That's Mr. Pickens, his testimony on who owned what and when. This motion that's being offered is completely contrary to everybody that actually was in the deal. All right, it's clever, but it's not real, okay? And all the actual parties to the participation agreements and to this assignment all operated for years under the understanding that the participation agreements had rights, including the right to the back end that still existed, while they owned the interests that were invested in them through the assignment. And in fact, Enervest, one of the defendants here, who then conveyed on to Magnolia, the other main defendant here, both took expressly subject to the participation agreements. And that's Exhibit N in our record, paragraph 7.7, 7.7, paragraph C. All right. So it's a fallacy. Okay, the whole motion is a clever idea, but it doesn't track reality. And even the lawyers in this case only are just learning about it because prior, you've heard arguments, I think it was a year ago, roughly to the day, that we had argument about the mistake or not mistake, and did Lundberg intend to convey the back end or did he not in connection with the settlement agreement? The court may remember those discussions. If there was,
I have a memory. I don't know that I remember as much as the attorneys.
That's fair, sir. But we talked about it for hours in your lovely courthouse about whether Lundberg conveyed back to Mithril or was supposed to convey back to the participants in the settlement agreement this interest, which they are now telling you he never had because he conveyed it back at the beginning of the deal, which again makes no sense. They also argued they have another motion for summary judgment on file that says that the back-end interest only applies to the existing leases and not other leases, amendments, and interests. Now, I guess that will be explained under the same sort of, oh yeah, we're just assuming it's a valid transfer, but that was never when it was first filed, that was never out there. I mean, the fact is, like, everybody has been marching in lockstep for 20 years, including the lawyers, until they finally come across this clever argument that just is divorced from reality. So now I promised you we'd talk about the assignment itself, and so we will try and do that here.
And is this the document that says assignment, conveyance, bill of sale, starts out FRG Investments?
Not that one, sir. It says that title, but it says Lundberg Operating, and then ultimately it's to a series of investments.
Okay, but FRG Investments, the first assignee.
Oh, sorry, I misunderstood your question.
Okay,
yes, sir.
Well, I wasn't clear. The first assignee, it does start out Lundberg Operating. Okay, go ahead, sir.
Okay, so the argument is whether they meant to or not, oopsie doopsie, the Lundbergs assigned out 100% of their right, title, and interest, and that means everything they ever received, and except for what was reserved. And the things that are reserved are set out in the document. Now, number one, that just can't be true unless everybody's a moron and didn't know what was going on, because for years afterwards, parties followed the participation agreement in other respects, not just with respect to the back-end interest, even though everyone recognized that existed and was valid. They followed it with respect to operations, with respect to reporting obligations, with respect to the operations of the gas entity, and we set it out in the brief, but there's a whole bunch of parts of the participation agreement, which up until now, no one ever said was gone. But if you follow the defendant's logic here, all of Lundberg's rights was also conveyed away. And all he reserved was a small fraction of a percentage and an override, which of course defies the party's experience. So here we go. This is the conveyance. And you talk about, okay, so you have the FRG investments, 1.5% on a big table. These are all the participants. And then there's a separate list that talks about the Rezapa wells, which doesn't really come into play here. And then there's an exception for the override. And they say, that's all there is, stop reading, and that's why we win. Well, first off, there's nothing that says expressly at all the back end is included. Let's be real clear about that. And secondly, there's more. It says this conveyance bill of sale is made and accepted subject to the terms of the following instruments. Okay, well, what instruments? First, we'll start here. The letter agreement, oops, I said the wrong one. We'll start here, the letter of understanding, which is C. The letter of understanding, of course, is the document by which Mr. Lundberg and Compass agreed that the Compass back-end would be half of whatever the Lundberg back-end was. So it's in there, okay? Second, on E, there's a letter dated December 2nd, 2001. That is, fundamentally, it talks about we're going to be using the JOA, which is referenced in A, so I don't want to spend too much time on it, but it says that the JOA describes the properties, and the new JOA, this December 21, 2001, is going to be the live JOA. And that's what I want to focus on here is this, the JOA. Okay, well, why is the JOA important for the purposes of this motion where they say nothing was reserved and the back end was, even though not named, expressly conveyed away? Let's look at that. JOA excerpts, which were filed in the record in connection with a different summary judgment motion. Here we are. Oops, I've done it wrong. So the JOA, Exhibit A to the JOA, talks about the ownership interests that are going to be covered and associated with the transaction. So first is a description of the contract area. Okay, it is the AMI, easy enough. That goes on. And the first section here, you'll see, Your Honor, in Article 3, that's again about the Rezepa wells. Doesn't really matter too much here, so we'll fast forward to the second part. And here's where it gets interesting. As to the remainder of the contract, here's what happens to the interest before and after payout. Okay, well, what happens? With respect to Compass, Compass goes from 0% to 12.5%. Why? That's half of the 25% back in that everybody knew existed at the time and is documented here in the document that's referenced in the assignment they say gave it away. Okay, well, that's interesting. What happens to Mr. Lundberg? Okay. Mr. Lundberg starts with a 2.5% interest. After project payout, he goes up to 14.375. Why? The 2.5%, like all other interests, is reduced by the quarter, that is the back end, and then reassigned out by 12.5% to Compass and the other 12.5% to Mr. Lundberg. It's express in the document. That's how the project payout works. And if there's any more questions, it tells you where to look to define project payout. Okay, the AMIPA. There's no assignment out of this back end. Number one, everybody knew they we're not assigning out the back end. Like that's just silly. Number two, the assignment itself reserves and accepts and is subject to the agreement here. And the agreement here describes in vivid detail before and after payout. So the notion that the Lundbergs assigned out this right while in the very document that reflects the effect of the back end just cannot stand. And so,
and I'm sorry, what's the title of the document you're looking at right now?
This is the JOA, sir. That is the operative JOA in all of these transactions. It's and specifically we're looking at Exhibit A to the JOA, which is the list of all the interests. And if you, I mean, just one last piece to assuage everyone's concern about what we're talking about here, we can look and compare the interest. Remember we said our FRG investments, right? 1.5%. So we have the same FRG investments before payout is 1.5%, just like it is in the assignment. After payout, they get reduced to 1.125%. Everybody knew that is being reserved. Everybody knew that the Lundbergs retained this right. And all the talk about, is it a contractual right? Is it a property right? It's interesting, but ultimately it doesn't really matter. The reason, and frankly, it's both, is the vivid, I think Amir said it the best. It is a contractual right that gives right to a right in property. I think that was the best articulation I've ever heard of it, actually. And I think it's right, is that in the participation agreement, Lundberg has a right that gives him ultimately a right to a property interest. The conveyance out, but that's a different issue than the conveyance out. The reason we get into it's a contract, more like a contract, more like a property right, is when we're talking, we thought the defendants were saying, oh, by implication through the merger doctrine, da-da-da-da. They're not saying that, okay? They're saying expressly Lundberg assigned these interests out. And I've just showed the court expressly they were reserved in the assignment by reference to this operating agreement that has the Exhibit A that shows the exact, to the decimal, interests that are owned before and after payout.
And do I have a copy of that, or did you say that it was attached to another motion?
Yes, sir. It's attached to a different motion. I can point to it is Exhibit 6 to the defendant's opposition to the mutual mistake motion. Sorry. And that's also on the docket for today, but has not yet been argued.
Okay, go ahead.
That's it. I mean, fundamentally, this is like, I'm gonna rail a little bit here, but I mean, fundamentally, what we have here is very smart, very good lawyers working for entities who are willing to pay the bills to look through all the documents and pick out whatever like thread they can try and find on this transaction. But the reality is none of the defendants were parties to the transactions, with the exception of Compass. And none of the people that are telling us now, oh, this is what the deal was, were actually there. And every one of these arguments, I really want the court to listen and see, how does it resonate with the facts and circumstances and context of the transaction itself? So far, both of the ones we've heard today do not. And they're both the same kind of thing. There's these rifle shot, Hail Mary type emotions. And if I win, yay. And if I don't, I'll just move on down the road. But that's, they're literally divorcing the record that's before the court from the overall transaction. This transaction is complex, yes, but all of the pieces fit together. And I encourage the court to only make rulings where the pieces fit and not make these incongruent rulings. Because if you see the different motions you're gonna be hearing from the defendants, none of the pieces fit together. And that's what we're dealing with, sir. Thank you.
Your Honor, may I reply?
Yes.
Thank you. So, Your Honor, you just heard a lot about intent and circumstances. I think we should be clear. The conveyance, and let me pull it up on the screen. Okay, so the conveyance by LOTCO to the participants filed of record is what's important in this case. It is what the court has to construe by its four corners. There has been no allegation of ambiguity. It is not ambiguous. There is no back-end reservation in this document. And so all of the discussion about, everybody knew this, and I disagree with that, and I can go into it, but it doesn't matter. I mean, this is, as a matter of law, this is for the court to decide, was the back end reserved under Texas law in this document? If no, Mithrail does not have claims. And Mr. Charest, I'll address the JOA argument in a second, but he didn't go through these terms because it is not in here. And so on page 5 here, this is what he showed, where there's some, this assignment is made and accepted subject to the terms and provisions of all of the following instruments here. First of all, this is the Jarzombic case. It is this court's case that was affirmed by the San Antonio Court of Appeals last year on this issue. If as Mr. Charest argues, that the JOA referred to or created, even though the JOA expressly doesn't say, or expressly says that it does not create interests, but even if it did, saying that this assignment is made subject to an agreement that does create interest does not mean that you've reserved it as a matter of law. That is not clear language. You have to reserve your interests clearly with clear language in the instrument itself. It is not here. The other thing that is not here is the letter agreements. Those 21 participation agreements that the testimony that you saw was talking about, and Mr. Kasman has talked about, Mr. Pickens has talked about, those agreements do talk about a back-end for Mr. Lumber, or for LOTCO, excuse me. That is true. What is also true is that they were not reserved in this assignment. And so under Jarzombic and Cosgrove v. Cade, they passed. The back-end rights passed. So to address the JOA argument, briefly, I mean, not only, the first point is that this is Jar Zombek, but the second point too is, I don't have the JOA handy because this was not an argument that was raised in the briefing. This is brand new. But the JOA, if you noticed in that chart, it said that Mr. and Mrs. Lumberg personally apparently were going to get the back end. Well, that's not even what the letter agreements say. The letter agreements say that Lopko's getting it. So if there's some back end alluded to in the JOA, it's not the one we're talking about. I mean, it's not the one that was assigned to Mithrail. But again, it doesn't matter because Lopko here is conveying 100% of its interests. Again, it's not even disputed. The only argument against that is, well, that couldn't be the case. Or, I mean, that this is a clever lawyer argument. Well, no, it's the document itself and Texas law. I mean, that, if I can also, just to address briefly the point that this is brand new and that, you know, there's had to be some pivot or new argument made today because we just made this argument for the first time recently. So what I'm sharing on the screen now is, this is Magnolia and Intervest's brief filed back in February, 9 months ago, after the court asked us about Cosgrove v. Cade and how it applied to this case. And we discussed all the ways it applies on the pending motions. And then the last thing we added down here in the footnote was it actually also supports summary judgment against Mithrail's lack of any title, because Lopko only reserved an override and did not reserve its back end. Lopko had no back end title to assign to Mithrail in 2002, negating Mithrail's claims. This is not something that we just made up and sprung on them. This has been out there. The reason it's being characterized like that is because there's no response to it. It is, there's no way to argue out of the document filed of record, the conveyance filed of record. Lopko conveyed all of its interests and did not reserve a back end. I mean, the interesting thing is, because Mithrail is not Lopko, Mithrail actually needs Lopko to be able to assign a back end. It just needs its assignment that it got in September 2002 to be first in line. But it's not first in line. This right here, by its terms, is first in line. And so, as a matter of law, Mithrail did not get it. I'm happy to address any questions the court may have, but otherwise, we asked that Mithrail's backing claims be dismissed because it is indisputable, and by the plain language of this agreement and Jar Zombek, that Lopko did not reserve a back end.
Okay. Mr. Charest, anything else?
Well, I guess I'd just say that Jar Zombek was not like this. Jar Zombek was one assignment and they were done. It wasn't like contemplating further obligations in a 20-year relationship. So obviously they are different. And you don't have this detailed, complex relationship with assignment being part performance, whereas it is full performance. And that's the fundamental difference. And that's why we think of Jar Zombek as a merger doctrine kind of case, not the way it's been applied here. All of their arguments presume, oh, it was assigned and therefore it's assigned. But the document itself belies that by reference to the JOA and the tables that we saw.
Okay. What other motions do we have left today?
Your Honor, with those two done, the next motion is plaintiff's motion for summary judgment on mutual mistake. And then there were two discovery motions, but given where we are on the calendar, one of those will push to the next hearing. So there's one more summary judgment motion, this one from the plaintiffs, and then there's one discovery motion. But as to both, we're at the court's pleasure on how much or how little of that we can get through.
All right, well, let's take a break until 2:45, and then I have a hard drive away time. I have to be home when my son gets off the bus. today. So I bet 4:15 is when I need to leave. So I don't know, you think we can get both of those done today or just one? But I will see you back here at 2:45.
Thank you, sir.
Thank you, Your Honor.
And we can talk about that too, Alex.
Yeah, let's do that in a second.
If any of the attorneys need a breakout room, if you would get in touch with Miss Riley, she is the host right now and she has to do the breakout rooms.
Judge, I sent you some chat messages on a case or two.
Okay, I'll look at them briefly or in a moment. Oh, the first one, I got something from the Frio district clerk. I don't even know what it's about. It just says to me, I think it's nice size. Or
Yes, sir. Yes, sir. So I think it's the
Sent them
nice size, but that Sunny Viesca, they're saying he did not get notice of the setting today. They want to know if the nice size should be recalled or not.
I haven't signed anything yet, so.
No, sir, you have not.
Yeah, no, if he didn't get notice, I mean,
Okay.
we'll send him notice. If he didn't show up after we send him notice because he gave us the wrong address or he lied about his address or didn't update it, that's on him. All right,
Okay. I'll reset that one to 11:23 if that's okay with you.
sounds good. I will get these back in just a moment.
Thank you, sir.
Okay, are we ready to start on the mutual mistake motion for summary judgment? Actually, Mr. Alvey, let him get back. Okay, so we're ready on the mutual mistake, partial summary judgment?
Plaintiffs are ready, Your Honor.
Yes, Your Honor.
All right, how many defendants are going to be speaking?
Your Honor, it's Alex Kaplan. I'll be speaking on behalf of the defendants in response to plaintiff's motion.
All right. All right, go ahead, Mr. Charest.
Your Honor, be Mr. Cox here for the
I'm sorry.
Plaintiffs. So a little introduction to this motion. Defendants have pled as two different affirmative defenses, the mutual mistake of fact and also Scrivener's error. They're similar but different. This motion targets the affirmative defense of mutual mistake of fact only. We'll go through this. There is a lot of dispute. It's heavily disputed whether there was any mistake in the first place, and if there was, who was mistaken. But all of that can be set aside because the thrust of the motion is that as a matter of law, if there was a mistake, the defendant's predecessors assumed the risk of that mistake when they accepted the quitclaim and made a number of representations in the documents that they signed. Here's the difference between a mutual mistake of fact and a Scrivener's error. And I understand this is basic, but I thought I would cover it just to set the foundation. A mutual mistake of fact is when you're wrong about a fact that underlies your agreement. You think the sky is red instead of blue, for instance. A Scrivener's error is when you're right on your fact. In other words, you know the sky is blue and that's correct. But then when you go to draft your agreement, you write red in the agreement on accident. Those are the two differences. The mutual mistake of fact is you're wrong about reality, but at least you accurately transcribe your incorrectness into the draft. Whereas a Scrivener's error, you're right on reality, but you make a mistake when you try to put it down on paper. You can leave aside, again, all the dispute about who was mistaken, if they were mistaken, and what all that means. Because, again, as operation of law, if there were any mistake, the risk of it was assumed. The particular mistake that defendants allege is that they were mistaken, and they say both parties were mistaken as to who held title to the Lopco backing. In other words, who owned the Lopco backing. The defendant's mistake is that they say all parties thought that Lopco held the back end at the time of the settlement agreement in 2003, and at the time that Lopco issued a quitclaim to the disgruntled partners. That's the mistake that's in play. Here's a big picture overview. The law is well settled that you don't get relief for mutual mistake if you've assumed the risk of your mistake. We're going to talk about a keystone case on this issue, Geodyne Energy, that applies that basic black letter law to quitclaims. Then I want to look at the mutual release and look at the various disclaimers that the counterparties or all parties made in that document. Lastly, I want to talk about the absence of silence, misrepresentation, or inducement, because those are the only ways that you can get around assuming the risk of mistake in a quitclaim. Geodyne Energy. This is a 2005 case from the Texas Supreme Court. It looks at the issue of whether a quitclaim has to be set aside because the grantee, the buyer, thought that what it was getting was something different than what it actually got. In Geodyne, the mistake was that the buyer thought that the interest it was getting was an interest associated with a valid producing oil and gas lease. Turns out the lease had expired, and all the buyer was left with was liability for basically all the after costs. They tried to get out of that agreement by alleging in part that the sale violated Texas Securities Act and that that there had been a misrepresentation and or mutual mistake, lack of or misunderstanding. Texas Supreme Court cited directly and quoted this passage from the Restatement of Contracts. You bear the risk of mistake in 3 different instances. First, if the risk is allocated to you by agreement. Secondly, if at the time the contract is made, you are aware that you have limited knowledge, at least with respect to whatever the mistake happens to be, but you treat your limited knowledge as sufficient. And the third is when the risk is allocated by the court on the ground that it's reasonable to do so in the circumstances. So the focus on this motion is really on these first 2. It's not that we don't think it would be reasonable for the court to allocate the risk. It's just that all of that is implicated in A and B. Here, the risk was allocated by agreement in both the quitclaim and the mutual release. And then part B here is also implicated because the counterparties, LOPCO's counterparties and Mithril's counterparties were aware that they only had limited knowledge, but they proceeded anyway. This is again from Geodyne. What Geodyne does is it restates this or repeats this basic principle. Look, if you intentionally assume the risk of mistake, you can't get out of your deal. And then importantly, Geodyne points to quit claims and says, look, the restatement uses a quit claim. That's the textbook example of assuming the risk. And of course, the risk you assume in a quit claim is the risk of title, that the grantor doesn't have what it is that you think you're getting. It's because a quit claim deed upon its face has doubt. If you're the buyer, you're necessarily put on inquiry as to those doubts. And they cite all the way back to a case from 1887. It just shows how well ingrained the concept of a quit claim is. And that everyone knows, and it's so long established in the law, that that's what a quit claim does. Doesn't mean that you have anything, but whatever you do have, you're granting. The defendant's response is that Geodyne was limited to its facts and or that in any event, the facts are different here. And both of those are wrong. Here's the passage that they take that from. The defendant said, well, we didn't breach the agreement if there's either mutual mistake or no meetings of the minds. The court said, but a quit claim deed cannot be set aside on either basis under these facts. Now, first of all, Geodyne's statements about quit claim deeds, about the doubts that they convey, and about what they do and don't mean, they're not limited to the particular quit claim deed that was in Geodyne. They're applicable to all quit claim deeds. That's why they cite back to a case from the 1800s. But in any event, the key facts from Geodyne are the same as they are here. First of all, the quit claim that we're examining is a quit claim, both cases. In Geodyne, the language said without warranty of title, either express or implied. That's exactly what we have here in the LOPCO quit claim. It's made without warranty, express or implied. In Geodyne, there was no evidence that the parties ever contemplated anything other than a quit claim. So in other words, the buyer wasn't under the impression in Geodyne that they were going to get a warranty deed, and then all of a sudden they ended up with a quit claim. The court said it found it important that they started out offering a quit claim, and that's what they got. They bargained for it, and they got it. That's exactly what happened here. This is the February 20th, 2003 settlement agreement between the Lombard parties and the bad partners. This is provision 3C. And from the beginning, this contract contemplated there would be a release, relinquishment, and quit claim. That's what was bargained for, just like in Geodyne. Finally, in Geodyne, and this was the key fact, this is the under these facts in Geodyne, is that the court said, look, the only way you get around the inquiry notice and the assumption of risk that is inherent in a quit claim is if there's a misrepresentation. And there's no evidence of misrepresentation here. And we're going to walk through it, and there's also no evidence of misrepresentation in this case. So all of those facts, all the key facts are the same here. So just as one example, we'll go more through this mutual release agreement. But paragraph 4, there were no representations, statements, agreements, promises, or warranties by any party. Right? You cannot more plainly disclaim any representations than with that language. The other fact that defendants argue in their response is that this case is different because the number of potential sellers was different. So in Geodyne, you had one seller and one buyer. And they say that's different here because the settlement agreement was with the Lundbergs. And that was a capitalized term that includes Lundberg Operating Company, Mithril Holdings, and the Lundbergs individually. And the defendant's argument is that the fact that there were 3 potential selling entities sets this case apart and distinguishes it from the rule of law that Geodyne explains. And we'll walk through this, but the answer is that no, it absolutely does not make one difference as to the outcome. So consider this. The mistake alleged is mistakenly thinking that LOPCO owns the back-end right. Well, if the counterparties believe that LOPCO owns the back-end right, then it doesn't matter who else they contracted with because they thought LOPCO had it, and it was LOPCO that they got the quitclaim from. Okay? That was their mistake. It's no different than in Geodyne where where the buyer thought that the seller had it, and it was the seller that gave them the quitclaim. Now, on the other hand, if the counterparties did not know which of the 3 entities owned the back end, they just thought, well, it's got to be one of Lundberg Operating or Mithril Holdings or the Lundbergs. Then we go all the way back to that restatement section B, which that means, well, they knew their knowledge was limited. In other words, they knew it was one of the 3, but they didn't know which one. And they were aware, obviously, that they didn't know which one. Nevertheless, they proceeded to accept a quitclaim deed from just a single entity. They didn't cover their bases. So having had that limited knowledge, having been aware of that limited knowledge, and then treating that sufficient treating that knowledge as sufficient brings them again within the concept of the restatement and Geodyne. They did their own investigation. They represented that it was to their own complete satisfaction. They said, we've got all the knowledge we need. We're not relying on anything else that anybody has told us. No reps, no warranties, no promises. We're going to go ahead, and they end up taking the quitclaim from just LOPCO instead of all 3. If that's the rubric we're under, they accepted the risk of mistake under 154B. If they knew all along or thought mistakenly all along that it was LOPCO specifically that held it, then we're just right back in the Geodyne world. And again, the quitclaim puts them on notice, and operation of law, they assume the risk of title. The mutual release also plays into that. And let me bring this up. This is paragraph 4 of the mutual release. This portion expressly disclaims any representations, statements, agreements, promises, or warranties by any party touching up or leading up to this agreement, except those expressly set forth herein in the settlement. This, again, is a settlement. There are no other warranties, representation, promises with respect to ownership of the back end in the settlement. It says the Lundbergs, meaning Lundberg Operating, Mithril, or the Lundbergs individually. Mutual release goes on. Each party to this agreement represents, acknowledges, and say, we're not relying on anything anybody else has said or not said during or about the making of this agreement. Again, it's hard to imagine how you can be more plain in disclaiming reliance or any representations from anybody else. Paragraph 5, we continue. We've all done our own investigation. We've had our own advisors. We were all completely satisfied concerning such matters. In other words, we accept the knowledge that we have. Now, I want to talk about silence, misrepresentation, and inducement together for a couple of reasons. First, misrepresentation under Geodyne is the only way that you escape the assumption of risk when you take a quitclaim deed. Second, defendants as an alternative theory of mutual mistake of fact argue that, well, if there was at least a unilateral mistake, i.e. the disgruntled owners were mistaken, and Lumberg knew about their mistake, that's equivalent by law to a mutual mistake. And that is the case, but only if Lumberg knew about their mistake and was silent or induced that mistake. Okay, it can't just be that you know the other party is mistaken. Okay, because if you're out there saying, "Hey," giving them the correct information, then there would be no liability for mutual mistake if you're out there doing what you can to give them the knowledge that they should have. So first of all, Lumberg was not silenced. And I know, Your Honor, that this is a plaintiff's motion for summary judgment, but silence is not an item that is subject to a factual dispute. You're either silent or you're not silent. It's not, there's no sliding scale of how silent or how loud were you. Either you make the statement, put information out, or you don't. And for 4 reasons, the record shows that Lumberg, rather than sit on his hands, spoke up. Lumberg was putting out the information to the whole world as that Mithril Holdings held the back end. So first of all, and I'll start again with Geodyne. When a quitclaim is issued, as a matter of law, it conveys upon its face doubts about the grantor's interest. It puts the buyer on inquiry. Okay? A quitclaim is a disclosure. The document itself discloses that what the seller has might turn out to be nothing. That's taken directly from the Texas Supreme Court in Geodyne. The second item. What you're looking at here, Your Honor, is Plaintiff's Exhibit R. This is a draft settlement agreement. This draft came from Jack Roach. Jack Roach was the attorney for the subset of owners that were in the dispute with Lumberg. Roach sent this draft over to Lumberg. Lumberg looked at it and made these notations. First of all, as you can see here, he crossed out lock. Lock was a reference, capitalized reference, defined term to Lumberg Operating Company. And he replaced it with Lumberg's, the capitalized Lumberg's, which was defined to be Lumberg Operating Company plus the Lumberg's individually plus Mithril. And next to this, he wrote Mithril has. Now, it is absolutely true that Mr. Lumberg testified honestly that he doesn't recall why he wrote Mithril has there. Okay? But the only possible inference to take from this is that Mr. Lumberg was aware that Mithril has the back end, and he personally made the edit that changed this provision, which deals with the back end, from just obliging Lumberg Operating Company to bringing under that tent Lumberg Operating and Mithril, so that Mithril would be obliged to transfer the back end. There simply is no other inference that can be drawn from this, and the defendants haven't offered it. Roach then accepted the change, which we know because this is the final settlement agreement. The draft was lock. Mr. Lumberg crossed it out, wrote Lumberg's. And this is how the final looked. So it's obvious that the change was accepted. No silence point number 3. Shortly after the assignments of the Mithril backend were filed in the public record, Mr. Lumberg wrote a letter to Bomber Engineering. Now, Bomber Engineering wasn't just a stranger on the street. Bomber was the hand-picked operator that this subset of owners picked to replace Lumberg Operating Company. And Bomber took over the assets, the project assets, following Lopko's resignation. So like the assignments go to Mithril, they're filed in the public record. And then here we go, about a week later, with a written notice to Bomber Engineering that as of August 20th, all right, title, and interest in the back end, is now held by Mithril Holdings. That's anything but silent. And then finally, they're assigned in the public records, You see the staff there on the left. This is the assignment from the Lundbergs individually into Mithril, but the entire chain from Lundberg operating to Mithril was put into the record, where, as you know, the public is charged with knowledge of what's in there. And by the way, this isn't a situation where these assignments were filed the day before the quitclaim was issued or anything like that. The assignments were put in the record months, probably 8 to 9 months before the quitclaim went out, and certainly in more than enough time that sophisticated parties who had conducted their own complete investigation could have and would have found this. So I wanted to address here a few items that are made in contentions and response. So first of all, it is inaccurate to argue that Lundberg admitted that he didn't notify his counterparties of the transfers. Mr. Lundberg testified, again, honestly, that he had no specific recollection, didn't recall doing that. But he also testified that he was sure that Jack Roach knew, and he also pointed to the letter to Bomber and the fact that the assignments were in the public record. Now, the defendants have complained that that Lundberg did not make a written communication pursuant to the joint operating agreement notifying the partners of the transfer. But they assume without any reasoning or proof that that the transfer of the back end even would have been subject to the JOA in the first place. And in any event, just because you don't get notice via one means doesn't mean that the other party was silent as to every means. Clearly, Mr. Lundberg was putting the information out. Okay? For example, through the letter to Bomber. And then finally, in Boulder, we shouldn't lose sight of the fact that the only reason in the record that Mithril was even included in the back-end provision in the settlement agreement is because Chuck Lundberg personally changed the agreement to include Mithril after Jack Roach got it wrong. There are no misrepresentations. Again, to beat this horse, it's expressly disclaimed. If there were any evidence of misrepresentation, I can guarantee you it would be in this record and you would be aware of it. It's not, because there were no misrepresentations. There's also no inducement. In other words, Mr. Lundberg did nothing to induce the other party's mistake. The argument, one argument is that by signing the mutual release agreement, which was done on May 1st, that in some form or fashion induced the bad partners into believing that LOPCO held the back end. But we've already looked at the testimony from Mr. Pickens just on the last motion, and that's on the record here too. Pickens thought all along that LOPCO held the back end. You can see from the draft settlement agreement that was just locked that Jack Roach thought all along that LOPCO held the back end. Mr. Lundberg's signing of the May 1st mutual release did nothing to change their knowledge, because assuming they were mistaken before this document and were mistaken all along. Secondly, it boggles my understanding to see how signing an agreement that says there's no representations, no promises, no warranties, not relying on anything anybody else said or may have said, that in everybody signing that agreement, disclaiming express promises, that operated as an implied promise that LOPCO held the back end. And to be clear, that's not exactly, when you look at the briefs, what defendants argue. Defendants argue that this was an implied promise that Lundberg was going to follow through on the settlement agreement. And of course, that's pretty hotly disputed. But the point is, really, that wasn't the mistake. The mistake was who owned the back end, not whether or not Lundberg or Mithril would perform its obligations. And in any event, because this was on May 1st, 6 weeks before the quitclaim. So having put you through enough slide torture, I'll come back to where we started, which is this motion is ripe for summary judgment. There are disputed issues as to whether and who, whether there was a mistake, what they thought, and who was mistaken. But here it's immaterial, because even assuming that there was a mistake, by operation of law, those counterparties assumed the risk of mistake, and therefore they can't assert it as a defense now. There's no factual dispute that they bargained for and accepted a quitclaim. There is no factual dispute that they signed the mutual release or made all the recitations that were in it. There is no factual dispute that Chuck Lumberg personally was the one who added mithril to the back-end provision in the settlement agreement. And there can't be any dispute that that change was accepted. Finally, there's no dispute that Mr. Lumberg sent notice.
Hold on a second, please. All right, go ahead.
Thank you, Your Honor. So there's no factual dispute to any of these things. And these are the material facts on this motion. In Rowland, the San Antonio Court of Appeals noted what is a fairly common principle in the law. You cannot avoid a contract on the grounds of mistake where your mistake is due, where your ignorance of the facts is due to carelessness, indifference, or inattention. Defendant's predecessors knew that LOPCO back-end was held by one of the three entities, all right, in the settlement agreement, either Lumberg Operating Company, Mithril, or the Lumbergs individually. They knew it was one of the three. They were aware of what their knowledge was and that it was limited. That's why apparently they claim they contracted with all three and not just Lumberg Operating. They also represented that they had done their own complete investigation to their own satisfaction. In other words, they treated their knowledge as sufficient. They proceeded anyway with accepting a quitclaim from LOPCO, which on its face conveys doubt and put them on inquiry notice that LOPCO might not have the thing that they thought they were getting. On those facts, summary judgment is appropriate on mutual mistake of defense, the mutual mistake of fact defense, because that's what the predecessors assumed the risk of, not knowing what the state of the title was. Thank you.
All right. And who's going to respond on this?
I will, Your Honor.
Go ahead,
if I may. Thank you, sir. Your Honor, I'm going to just to give a brief roadmap. Let me start by kind of setting the fact pattern that I think is relevant for the court, and then I would like to address, and I think I can do it quickly now, given what we just heard. But the way the motion was just argued, I think, is not necessarily consistent with how it was briefed. It was briefed as a no evidence motion on mistake, as well as a traditional motion. So I could quickly address the two no evidence points, because I think my friend said repeatedly that there is a factual dispute about whether there was a mistake. And indeed, there is substantial evidence on that. So I'll quickly address the no evidence points, because I think they help put into context the final point, which is the traditional motion for summary judgment, which is the Geodine argument. So first, Your Honor, just some quick factual context here. As the court now is familiar, although much of our time today and over the past two hearings has been spent entirely on the Mithril back-end claims, this case started out as a royalty dispute, and only a royalty dispute. Mithril wasn't even a party to this case. The case was on file for nearly a year before any claim with respect to the back-end. So what accounts for that delay? My friend, Mr. Teres, told us that, oh, everybody has known forever about this back-end, and this is all just clever lawyering. Well, talk about revisionist history, to use his terms. For more than a year, this was a royalty case. No one even thought about the back-end claim. Why not? The plaintiffs didn't even believe they had a claim to the back-end. And that's because, Your Honor, of the settlement agreement from 2003 that the court has heard argument on and is relevant to some of the pending motions, which expressly required all of the Lumberg parties, LOPCO and Mithril, and Mr. and Mrs. Lundberg, to release, relinquish, and quitclaim the back-end interest, all of them. The very interest that they're now in court claiming. A contract, the settlement agreement under which the plaintiffs have received every benefit to which they were entitled, and they have retained those benefits to this day. And from 2003 forward, for 15 years, the plaintiffs believe they had, in fact, released, relinquished, and quitclaimed the back-end. Mr. Lundberg admits that's what he told third parties. He admits that's what he thought. He thought he had given up the interest. He told us, Your Honor, in 2017, he had a lawyer write a letter to Enervest saying, based on what Mr. Lundberg told his lawyer, that Intervest owned the Lopco back-end. But it was in the context of this royalty dispute that Mr. Lundberg noticed that he might be able to try to capitalize on a mistake in the instrument that was signed to effectuate the relinquishment and release of this interest pursuant to the settlement agreement. So he's come up with a story for purposes of the lawsuit, and we think the evidence shows it's a complete contrivance. The story is that this settlement agreement actually was called off, even though he closed it and accepted all the benefits under it, and some other agreement was reached. And under that other agreement, not documented anywhere, the intent widely shared was that he would keep his back-end interest. The story is not supported by any contemporaneous documents or any witness other than Mr. Lundberg himself. And it's contrary to common sense, Your Honor. If Mr. Lundberg's, if Lopco was not giving up the back-end, if he was retaining it, as he now says was the intention, despite the express obligation to the contrary in the settlement agreement, and therefore if the owners, our predecessors, were not getting anything, then why did Lopco sign a release, relinquishment, and quitclaim in their favor if they weren't supposed to get anything in the first place? In his deposition, Judge, I asked Mr. Lundberg, you've been in the oil and gas business for 40 years, sir. Have you ever signed a release, relinquishment, or quitclaim with respect to an interest that you don't own? No. And how about in favor of an entity that wasn't getting anything under the transaction? No. He laughed at the suggestion in the second deposition. It's illogical to the extreme. In any event, what they didn't count on, Judge, when they came up with this story and changed the whole nature of the lawsuit is our ability to disprove it, because it did happen 15 years ago. But we've now found contemporaneous documents that prove this was indeed a mistake. A mutual mistake of fact. The parties believed that Lopco held the interest at the time and therefore believed the obligation of the settlement agreement was being discharged. It's what the contemporaneous documents say. It's what the testimony from one of the few owners still alive confirms. It's what Mr. Lundberg says he thought at the time and what he thought for 15 years, what he told others, what he told us in 2017. So that evidence, which I just summarized, is more than sufficient to create a fact issue on the question of mutual mistake. It's a mistake that both sides operated under for more than 15 years and for almost a year into this lawsuit. It is more than sufficient for a jury to be charged and given the question of mutual mistake. So plaintiff's motion, Judge, raises 2 no evidence points and 1 traditional point for summary judgment. The first no evidence point is that we have no evidence of mutual mistake. They say we have no evidence that the owners were mistaken. The second point, they say that there's no evidence on the doctrine of unilateral mistake plus knowledge, which Texas law treats, and I think I heard Mr. Cox say that he agrees, treats as a species of or equivalent to mutual mistake. And that's the Davis v. Grammer case from the Texas Supreme Court. And that's in the pattern jury charge 101.28. As to both points, Your Honor, there's well more than the scintilla of evidence required to create a fact issue, and that the no evidence motions ought to be denied. With respect to the summary judgment, or the traditional summary judgment point, that the contract, somehow allocated the risk of mistake to us. That is not right either, Your Honor. And I'll just summarize the point and then we'll get to it in more detail. The plaintiffs rely almost exclusively on the Geodyne case. But Geodyne, they're misreading, or I think overreading. The Geodyne case is different from this case in precisely the respect that led to its holding. In that case, Your Honor, Party A promised to give a quitclaim to Party B of the entire interest that Party A held. And Party A did so. Therefore, Party B got everything that it contracted for. It got full performance under the contract. So when it turns out that Party A didn't have the interest that Party B was hoping to get, Party B can't seek reformation or avoidance of a contract obligation on the grounds of mistake because it got everything it was promised. You can't use a mistake to expand the scope of the contractual obligation. But that is precisely the opposite of the fact pattern here, Your Honor. We didn't just contract with Lopco for a release, relinquishment, and quitclaim. Section 3C of the settlement agreement puts an affirmative obligation on all of the plaintiffs, including Mithrail, Your Honor, to release, relinquish, and quitclaim the back end. We didn't assume the risk that Mithrail didn't have it. We bargained to protect ourselves to get a release, relinquishment, and quitclaim from all three parties. Therefore, there's no assumption of the risk as to which party had it. The fact pattern is a mistake that the parties thought that obligation was being discharged. But unlike Geodyne, Your Honor, we're not relying on mistake to expand the scope of the obligation. We have an express obligation here for all three parties to give us the interest that they had. So just quickly, Your Honor, I will run through the no evidence points because I think the way Mr. Cox argued it, these are also relevant to his traditional points. First, on mutual mistake. The legal standard is straightforward. It is from the pattern jury charge 101.28, mutual mistake. A mutual mistake results from a mistake of fact common to both parties if both parties had the same misconception concerning the fact in question. And of course, the no evidence standard of review is familiar to the court. We need only point out a challenge fact issue. We don't have to marshal our evidence. There's significant evidence here of this mutual mistake. Just to tick through it. First, Mr. Pickens, one of the few owners who's still with us today, testified, and you've seen this testimony today. He believed the LOPCO back-end was held by LOPCO before it was released, relinquished, and quitclaimed. That's quoted at page 10 of our brief. It's Exhibit 13. 2, and this is really the most probative evidence, Your Honor, the contemporaneous documents, not what a witness with a $200 million incentive, as Mr. Lundberg is, tells you, but what the parties wrote and thought at the time in 2003. We have contemporaneous documents from Mr. Roach, the owner's counsel, and I refer you, Your Honor, to Exhibit 14, Exhibit 18, and most importantly, Exhibit 20 to our response. In Exhibit 20, the key portion is actually excerpted and quoted at page 12 of our brief. And that is from Mr. Roach, the owner's lawyer who dealt directly with Mr. Lundberg, reporting to his clients, a lawyer with a fiduciary duty of candor. So there's substantial indicia of reliability in these communications. He reports to his clients that he had received, and he encloses the release, relinquishment, and quitclaim. And he says that he's received it from Mr. Lundberg, and as a result of the instrument, all, that's his word, all of the reversionary interest has been released. He says the interest acquired by you is no longer subject to the additional reversionary interest, referring to the LOPCO back-end. That is contemporaneous documentary evidence of the owner's understanding at the time that by virtue of signing that release, relinquishment, and quitclaim, the interest was being released. That is substantial evidence of a mistake, Your Honor. At the very least, with all inferences in our favor, it creates a fact issue on the question of mistake. But we have more evidence, Your Honor. Again, we have Mr. Lundberg's own testimony that he was mistaken. Right, he says he told third parties this for years. This is quoted at page 13 of our brief. It's what he told us in 2017. That's Exhibit 23, notes 49 and 50 to our brief. And Mr. Lundberg himself, Your Honor, testified that he thinks Mr. Roach was mistaken. And that's quoted at page 12 to 13 of our brief, Exhibit 15. Okay, Your Honor, you also have the release, relinquishment, and quitclaim itself. It's not just a quitclaim, it's a release, relinquishment, and quitclaim. The plain and ordinary meaning of the word relinquish is to give up. The instrument itself is evidence. The owners understood the executing party was giving up something, presupposing, or at least some evidence of their understanding there was something to give up. So that evidence is more than sufficient, Your Honor, to defeat a no evidence motion and create a fact issue on mutual mistake. And we cited the Hardy case, Judge, from the Tyler Court of Appeals, just to show that this fact pattern, which is mistake about the identity of ownership of an interest, can well be subject to a mutual mistake. And in that case, the court denied a motion for summary judgment on the defense of mutual mistake, which brings us, Your Honor, to their second no evidence point, which is Texas law has two species of mutual mistake of fact. One is what we just went through, which is true mutual mistake, a mutual misconception of fact. The second is referred to as unilateral mistake plus knowledge. And the way that the pattern jury charge describes it, Your Honor, is, to quote it, unilateral mistake by one party and knowledge of that mistake by the other party is equivalent to mutual mistake. And that comes directly, Your Honor, from the Davis versus Grammer Texas Supreme Court case in 1988, which finds mutual mistake based on unilateral mistake by one party and knowledge of that mistake by the other party. As to this theory of mutual mistake, the plaintiff's motion argued that we had no evidence that Mr. Lundberg knew of the owner's mistake and remained silent or induced it. So the first element, the mistake by the owners, is covered by the evidence, Your Honor, that I just summarized. The second element, Mr. Lundberg's knowledge. So here, Your Honor, the evidence of Mr. Lundberg's knowledge is his own admission that he was mistaken. That itself is more than sufficient to create a fact issue and prove that he was equally mistaken. That establishes our mutual mistake defense. But we also believe the evidence is sufficient for a jury, a reasonable jury, to find the alternative conclusion, which is that Mr. Lundberg knew of the mistake. And so, Your Honor, this is a situation where we think the evidence is clear. Both parties operated under this mistake. However, the evidence also permits the conclusion that Mr. Lundberg was aware that the owners were mistaken. And either way, Your Honor, that establishes a mutual mistake defense that can go to the jury. And here, the key evidence, Your Honor, is exhibits 14 and 18 to our response, which is correspondence between Mr. Roach and Mr. Lundberg about the draft form of the release, relinquishment, and quitclaim, where Mr. Roach sends the draft to Mr. Lundberg, and they have a discussion about the document. And in that discussion, Mr. Roach makes clear to Mr. Lundberg his understanding that the document will be not just quitclaiming, but releasing. He uses the word releasing the interest, which again shows that Mr. Roach, and therefore the owners, because the owners' knowledge was based on what Mr. Roach was telling them, it's the only evidence of the owners' knowledge at the time, believed that LOPCO had the interest and therefore was releasing it. And Your Honor, that exchange alone is more than sufficient to create a fact issue on the question of Mr. Lundberg's knowledge. And of course, issues of knowledge and intent are classic questions of fact, not appropriate for summary judgment. And that's even noted in the pattern jury charge itself on this issue, Your Honor. Pattern charge 10128 cites the Texas Supreme Court's decision in Davis v. Grammer finding mutual mistake for the proposition that, quote, the question of mutual mistake is for the jury. So let me just step back, Your Honor. There really are only two possibilities in this case with respect to Mr. Lundberg's knowledge. Either one, he too was mistaken, consistent with what he has said and done for 15 years, including the first year of this lawsuit, which establishes, or at least creates a fact issue on mutual mistake, mutual misconception of fact. Or alternative two, he knew that LOPCO didn't have the interest, and thus only having LOPCO sign would not discharge the express obligation in Section 3C of the settlement agreement to release, relinquish, and quitclaim, as Roach thought the parties were doing, and Mr. Lundberg remains silent in the face of that mistake, which establishes our defense of unilateral mistake plus knowledge, the other species of mutual mistake. There is more than the scintilla of evidence to support both of those theories and permit a jury to decide. Now, the plaintiffs have argued in their brief, they don't mention it today, but as the court reviews the papers, you'll see it, that these theories cannot, to use their term, coexist, that they're inconsistent. We don't need to debate whether they necessarily are or not inconsistent, Judge, because as a matter of law, we have every right to present alternative arguments to Your Honor and to present alternative arguments to the jury. Texas Rule Civil Procedure 48 specifically permits parties to state as many separate claims or defenses as they may have, and I'm quoting now, regardless of consistency. And the Texas Supreme Court in the JLG trucking case from 2015, which is 466 Southwest 3rd, 157, said, quote, parties may present evidence of alternative and even inconsistent theories, leaving to the jury to choose the theory that it believes based upon its resolution of the conflicting evidence. And we even cited a case, Your Honor, from the Corpus Court of Appeals, the Wright case, which recognizes this principle of alternative argument and permits a defendant to proceed on alternative theories of mistake, both a mutual mistake based on a Scrivener's error and a mistake based on fraud. So, Your Honor, I think that's more than sufficient to deny the summary judgment motion. Now, I will note here, before we address Geodyne, that Mr. Cox went through some of the plaintiff's own evidence, which we respectfully submit is procedurally improper on a no evidence motion. We're not weighing conflicting evidence. The only question here is whether we have presented in response to their motion more than a scintilla of probative evidence to create a fact issue. But even on its own terms, the plaintiff's evidence does not prove what they say, and it certainly doesn't do so conclusively, Judge. So first, they point to the filing in the public records of the transfer from WAPCO to Mithrail. But the reality here, Your Honor, was there was no trigger for anyone to go search the public records, because in this case, the parties here had a JOA, which is Exhibit 6 to our response. The JOA expressly required notice, written notice to the owners themselves, our predecessors, of any transfer. And I believe Mr. Cox said there's been no showing that the JOA actually required such notice, but that's incorrect, Your Honor. If you look at Article 8F of the JOA, it says very clearly, should any party desire to sell or otherwise dispose of all or any part of its interest under this agreement or its rights and interest in the area, it shall promptly give written notice to the other parties within 15 days of the closing of such sale or disposition. I mean, otherwise dispose of couldn't be broader. That plainly covers a transfer of the interest. Now, we think the transfer from WAPCO to Mithrail was a sham for no consideration, but at least on its face, it purports to have been for consideration. It's a sale. It's certainly a disposition. So that provision plainly applies, and there's no evidence they provided us with that notice, which is required. They also cited, Your Honor, notice that was given to Bomber Engineering, which was the new operator who replaced Mr. Lundberg. But notice to Bomber is not notice to us. The JOA doesn't say notice to Bomber with respect to a transfer. It says notice to the owners. We didn't get notice, and Bomber's knowledge, there's no theory of law that would impute his knowledge to us. He's not our agent. At most, he's a contract operator. So that argument doesn't suffice. Finally, Your Honor, they point to, and Mr. Cox, actually, would you be so kind as to show your slide 35 that you showed the court? I apologize for asking that, but that would be helpful. So, Judge, this is the handwritten notation from Mr. Lundberg that Mr. Cox referred to on the draft of the settlement agreement. And the plaintiff's argument here is that Mr. Lundberg told Mr. Roach that Mithrail had the back end. But that's not what the record supports. Mr. Cox, I think, candidly acknowledged that Mr. Lundberg acknowledged in his deposition that he had no recollection of ever telling that to Mr. Roach. So that's the record. Thank you very much. So that's the record from Mr. Lundberg. He did not testify, he has not testified, and he cannot testify that he ever told Mr. Roach that Mithrail held the back end. Okay? So what plaintiffs are doing now is they're trying to get an inference in their favor. Of course, we're the non-movement. We get all the inferences, Your Honor, but we don't even need the inferences here because they have not established that their inference is even correct or even plausible. They say here that the only reason, Mr. Cox said, to write Mithrail has it here was with respect to the back end. But that's not true, Judge. If you look at this provision, what it says is that the Lundbergs, which was changed to the Lundbergs, the defined term, all of them will release, relinquish. That change was made to the agreement as a whole. And there were other conveyances in this document, including leasehold interests, where Mithrail did hold that interest. So the defined term Lundberg needed to be changed to include Mithrail for reasons independent of the back end. Point one. Point two, this very provision, if you look at the bottom, has a reservation. And it's a reservation saying that Mr. Lundberg will assign all of his interests, but he will retain the overriding royalty interest. Mithrail held the overriding royalty interest. So an equally plausible inference here is that Mithrail is referring to the overriding royalty interest, Your Honor, and not the back end interest. But again, we are entitled to the inferences, not the plaintiffs. And I point out, Judge, this document comes from Mr. Lundberg's files, not Mr. Roach's. There's no evidence this was ever transmitted to Mr. Roach. There's no evidence that it was ever discussed with Mr. Roach in terms of Mithrail owning the back end. So, and again, just to be clear, Your Honor, the point on this motion with respect to the no evidence motion is not whether a mistake was reasonable, should have been made, shouldn't have been made, whether someone's apportioning fault. I mean, this is not a tort claim. The question is the fact question. Was there a mistake? On that, there's more than sufficient evidence. And just on that, Mr. Cox did cite one case to you at the end there, the Rowland case from the San Antonio Court of Appeals in 1978. That was a case they cited for the first time yesterday. And he cited it for the proposition that a contract can't be avoided on grounds of mistake of fact if the mistake is the result of carelessness, inattention, or indifference. But my friend is not fairly presenting the law to Your Honor there. That case deals with a different doctrine of mistake, which is the pure unilateral mistake doctrine, not unilateral mistake plus knowledge, which the Davis versus Grammer case and the pattern jury charge recognizes is mutual mistake. Texas also recognizes a doctrine of pure unilateral mistake. It's a species of unconscionability, Your Honor, where a party is mistaken about a document. It goes to the heart of the bargain that was struck, and it would be unconscionable to enforce the agreement. And there, as the Rowland case illustrates, if you look at the case, one express element of that doctrine is the exercise of ordinary care. That is not an element of either of our mutual mistake theories in this case. It is beside the point. So, Your Honor, that brings us to the traditional motion argument that's been raised, which is the argument on Geodyne. Plaintiffs argue that regardless of all of that evidence of mistake, that our defense can't succeed because the risk of mistake was allocated to us by our predecessors by contract. And again, the argument is based on Geodyne, but they are overreading or misreading Geodyne. Again, Geodyne was a case where the buyer purchased an offshore lease at an auction, and the buyer received a quit claim from the seller of all of the seller's interest in the lease. It turns out the lease had expired and the buyer got no benefit from the lease, but did wind up with liabilities because there were plugging and abandoning liabilities. So most of the Geodyne case, when the court sees it, all but the last 3 paragraphs of the opinion deal with the claim under the Texas Securities Act. Only the last 3 paragraphs of the opinion deal with the contract claim and mutual mistake. And what the court says is with respect to the Texas Securities Act claims, those claims fail because there was no misrepresentation. The seller made no representation about the status of the lease or about its interest in the lease. And the court makes very clear that it is not saying, and this is at page 487, that a quit claim can never give rise to a misrepresentation claim. And I think this is really important, Your Honor, because Mr. Cox overreads Geodyne and presented it to the court as if once you have a quit claim, you basically can't have a mistake defense. Yet Geodyne itself is contrary to that. If you look at page 487 of Geodyne, this is a direct quote, Your Honor. Despite the merger doctrine, prior agreements are not merged into a realty deed in cases in which a quit claim deed is signed due to fraud, accident, or mistake. The very case that Mr. Cox wants to expand upon as a rule of law saying you can never have mistake under a quit claim says you can set aside a quit claim on the basis of mistake. The rule of Geodyne then is understood by what the court says at the end in the 3 paragraphs that address the mistake, where they say on these facts, the mistake defense fails. And it was because on these facts, the party claiming mistake got 100% of what it bargained for in the contract. It bargained for all of A's interest by quit claim, and that's what it got. That is not the case here, Your Honor. In this case, we are not seeking to expand the contractual obligation. We have under section 3C of the settlement agreement, which is part of the integrated final agreement. The settlement agreement and the mutual release and the closing documents are all part of the integrated agreement. The settlement agreement was not merged. It's not superseded. It is part of the integrated agreement, and it requires all of the Lumberg parties, including Mithrail, to release, relinquishment, and quitclaim. So unlike Geodyne, if we're party B, we're not asking party A to give us something it didn't agree to give us in the contract. We have the right to get everything we were promised in the contract. And so the question here is simply whether the parties made a factual mistake in believing when the quitclaim was signed that that party held the interest. So Judge, this is not a case where we're saying, oh, it turns out Mr. Lundberg had assigned it to someone who wasn't a party to our agreement, and we're now claiming that there was a misrepresentation or a warranty. That would potentially be an issue under Geodyne. Now, we have a indemnity under the mutual release, so we protected ourselves there as well. We didn't assume that risk, but that's not this case. That's Geodyne. In this case, we have a contract obligation for all of the parties to release, relinquish, and quitclaim. So it is a classic case of mistake, and Geodyne doesn't reach this fact pattern, Your Honor. Now, Mr. Cox then goes beyond Geodyne and goes to other provisions of the restatement that were not at issue in Geodyne. He talks about certain provisions of the contract, none of which are particularly germane, Your Honor. First, he points to the mutual release saying, basically to the integration clause, which is section 4 of the mutual release, where it says there are no other representations, promises, or agreements. Absolutely, Your Honor. We have no quibble with that. We're not relying on any other, something that's collateral to any of these agreements. We're not claiming there was some other agreement. Mr. Lundberg, as the court may recall from prior arguments, is the party in this case claiming that the written signed settlement agreement isn't the party's agreement and there was some other agreement. That's his made for litigation spin on what actually is a mistake. We embrace the written agreement. We don't need to go beyond it. We embrace section 4. But all section 4 says is we can't add an obligation. We can't rely on some other promise or representation, but we're not, Your Honor. Section 3 of the settlement agreement, which is incorporated into the integration clause, provides the right to get the release, relinquishment, and quitclaim from all of the parties. He also, in their briefing, Your Honor, they point to the mutual release itself, the release language itself, section 2. They say that we somehow released this claim, which truthfully makes no sense at all, Judge. At the outset, in order to allocate risk under the restatement, you have to do it expressly. And that's comment B to section 154 of the restatement. And we cite the Dallas Court of Appeals case in Para in our brief at 877 Southwest 2nd 352 that says it has to be specifically allocated. There's nothing in the mutual release that specifically allocates the risk. And if you look at the release provisions itself, we don't even release claims for breach of the settlement agreement. So how could we have released a claim for the failure to give us something under the settlement agreement? It makes no sense. But moreover, Judge, we're asserting a defense here on this motion. This motion challenges our defense. The release provision they're pointing to doesn't cover defenses. It covers claims. So the argument just doesn't work. They're pointing to contract language that has nothing to do with the allocation of risk. And they also point to language saying that, again, the integration clause as a disclaimer of reliance. But again, there's not a fraud claim here. At the time this was signed, the parties may have thought the language in section 4 would negate a fraud claim. Of course, as the court knows, the Texas Supreme Court subsequently in Italian Cowboy and in many cases has said standard merger clause language doesn't negate fraud. So that language just doesn't get them there. And you step back, Judge, what you see here is standard or customary language with respect to parties doing an investigation and consulting, which would be used to bar like a later claim of duress or compulsion under the Texas Supreme Court's cases in terms of consultation with counsel, or with respect to the integration clause that parties may have thought would be sufficient to waive a fraudulent inducement claim. But it has no bearing here on the issue of allocation of risk of mistake, because we're not using mistake to expand any obligation in the contract, just to show the parties made an error of fact in carrying out the express terms of their integrated agreement. So Geodyne just does not apply on these facts. Geodyne makes clear that even in the context of a quitclaim can be set aside on the basis of a mistake, and there is ample evidence of a mistake in this case. Your Honor, I'll just point out beyond.
Are you trying to set aside a quitclaim, or are you trying to obtain a remedy for the failure to execute a quitclaim?
Your Honor, right, we're not trying to set aside the quitclaim. We have a quitclaim from WAPCO, but the defense is they're claiming, one of their claims in this case is breach of contract for failure to assign the back end interest to Mithrail. We have as a defense, an avoidance defense, that we don't owe that obligation because that obligation should have been discharged and it wasn't by virtue of a mistake. So we're not trying to set aside WAPCO's quitclaim. We're simply saying that doesn't supersede the obligation of Mithrail to give us the release, relinquishment, and quitclaim under the settlement agreement. And I think your Honor's question, if I understand it correctly, kind of really gets at their motion is framed in terms of mistake, but what they're really trying to argue is merger. They're trying to argue that we're stuck with that closing instrument and there's nothing we can do about it. But Geodyne itself, Your Honor, says that merger doesn't prevent an avoidance defense, even in the context of a quitclaim, if it's based on mistake. And there's ample evidence of mistake in this case. So, Your Honor, I would submit to the court that given the robust record of mistake, including the plaintiff's own admissions, mistake ought to go to the extent this case is tried to a jury, and obviously there are a number of pending motions that we think would obviate the need for a jury trial, but to the extent the case goes to a jury, the jury ought to be charged on mistake. There's substantial evidence of mistake. The court can evaluate the legal sufficiency of the evidence on all the issues post-trial, but it would be, we believe, incorrect to grant summary judgment on this record with this substantial fact evidence for the plaintiffs in this case, particularly given that this case is truly the opposite of Geodyne, and plaintiffs don't have any other case that they've cited to you that's on par with the facts of this case, Your Honor. If the court has no further questions, I'll rest there.
The settlement agreement called for all three of the Lundberg parties to execute a quitclaim deed?
Yes, Your Honor, and that is section 3C of the settlement agreement, which is exhibit.
Page 6.
Yes, sir, it is exhibit page 6 to exhibit 3 of our motion. And the way you get to all three of the Lundbergs is the capital defined term Lundbergs on the first page of the agreement is defined to include WAPCO, Mithrail, and Mr. and Mrs. Lundberg.
And was the quitclaim deed from WAPCO a standalone instrument?
It was, Your Honor. And actually, that question reminds me of a point that I should have made and didn't make. It was a standalone instrument in this context, if I understand your question. There was the settlement agreement itself, and then there was a closing. And at the closing, there were a number of obligations, conveyances, assignments, transfers, and so forth. The closing occurred on the 29th of May, and that's when the signature pages to the mutual release were exchanged. One of the outstanding closing obligations that didn't happen until about 2 weeks later was execution of the release, relinquishment, and quitclaim. So it was a standalone instrument in the sense that it's a separate document, but it's a document that was executed pursuant to the express terms of the settlement agreement. But the point I forgot to mention that I think is important factual context, Your Honor, the release, relinquishment, and quitclaim wasn't even drafted until after the mutual release was signed. And the release, relinquishment, and quitclaim, Your Honor, which is exhibit, let's see, it is exhibit 19 to our response. You can see that it's notarized on June 11th. So it wasn't, and there's contemporaneous correspondence between Mr. Roach and Mr. Lundberg making clear that it wasn't even drafted or signed until after the settlement agreement and after the mutual release were signed, which I think is indicative of the fact that it was still an outstanding closing obligation. But this notion that when the parties signed the mutual release, they looked at the release, relinquishment, and quitclaim and were satisfied with it is just not correct factually in terms of the chronology. It hadn't even been drafted yet. The mistake hadn't been made yet. No one knew of such a mistake. It came 2 weeks later, Your Honor, and that's clear from the notarization on Mr. Lundberg's signature on the release, relinquishment, and quitclaim in Exhibit 19, which further undermines this notion of everyone looked at the document and was satisfied with it. That's not the case. And it's not the case factually based on the notarization that we know it didn't occur, it wasn't even drafted until 2 weeks later.
And what was the mistake?
The mistake, Your Honor, was a mutual misconception as to which entity currently held the interest in the LOPCO back-end at the time the release relinquishment and quitclaim was signed. LOPCO versus Mithril. Didn't
the settlement agreement take care of that by simply requiring all the Lundberg entities to execute a quitclaim deed?
It did indeed in terms of legal obligation, Your Honor. And therefore, we believe that all of the Lundberg parties were then and still are under a affirmative contract obligation to release, relinquish, and quitclaim it. But the mistake is because the parties thought LOPCO had it, they therefore thought that release, relinquishment, and quitclaim was sufficient to discharge that contractual obligation. It turns out,
well, just like in the Geodyne, where the contract was for a quitclaim deed and it didn't actually convey anything, but the grantee received what they had bargained for. Your predecessors bargained for releases and quitclaims from 3 different entities, and they only received a quitclaim from 1. So is that a mistake, or is that just?
So it is a mistake, Your Honor, and the question is why?
I mean, obviously it was a mistake, but is that a mistake in that didn't they know that they weren't getting what they had bargained for?
So, I mean, Your Honor, on the face of the instrument, it's signed by LOPCO. To your question, though, did they know they weren't getting what they bargained for? If they thought LOPCO had it, as the evidence shows, they thought that they got the release, relinquishment, and quitclaim of the interest. And that's clear from the contemporaneous documents. Mr. Roach says it on the day he received it to his clients, the reversionary interest is now gone. So I think, I mean, Your Honor's right that the fact that Mithril did.
They bargained for a quitclaim deed from the other entities, whether the other entities owned anything or not.
That is true, Your Honor. But because they were mistaken as to who owned it, it was not deemed to be necessary. They don't need a quitclaim from an entity that doesn't own it or is not believed to have owned it. So, you know, there could be an argument that somehow there could be a different doctrine that's argued somehow, that maybe they waited, you know, that they should have asked for it at the time, but it doesn't negate a mistake. The mistake is we believe, the predecessors believed that Mithril had it, or excuse me, that LOPCO had it, and therefore believed the release, relinquishment, and quitclaim satisfied the contractual obligation. That's clear from the contemporaneous documents. And that's different from Geodyne, Your Honor, because in Geodyne, they needed mistake to expand the scope of the contractual obligation. We don't need to expand the scope of the contractual obligation. We just need the plaintiffs to honor the contractual obligation. And that's why, I mean, separately, Your Honor, but that's why we have a pending motion that says on estoppel principles, they can't now claim the very interest they promised to release, relinquishment, quitclaim 15 years ago. And again, we're not relying on mistake to expand the scope of any contract obligation. We just need it to be the plaintiffs to live up to it and for the contract to be enforced.
Okay. All right. Mr. Cox?
Thank you, Your Honor.
Yes, Your Honor. I think that the questions are going to exactly the right point. The mistake of fact that's alleged here is we thought LOPCO owned the back end. Now, if you didn't get the obligation or the performance that you bargained for, that might be a mistake with a lowercase m, if you will, but it's not a mistake of fact that gives rise to a mutual mistake defense. If you don't get a performance, that's a breach of contract claim. Now, and so the question here is, was there or did they assume the risk of mistake as to who owned it? In other words, they know the performance they got. It was a LOPCO quitclaim. They want that, their defense is, well, either the quitclaim should have been from Mithril, and we would have made it from Mithril if we knew that Mithril owned it, but we didn't because we were mistaken. That's a mistake of fact. The other is, well, the quitclaim was supposed to be from all 3 entities, and it just said LOPCO. Well, if that's the case, that's a Scrivener's error, and that's not what this motion is about. This motion is about whether they assumed the risk of the mistake in title, i.e. who owned the back end. Now, there was, Intervest has its narrative and its view of all the things that went down with this transaction from 20 years difference. They have their story. There's also another side to the story, of course, but for this motion, it's okay for the court to assume that there was in fact a mistake, because the issue is, did they assume the risk of that mistake? Geodyne is 5 pages. I know Mr. Kaplan thinks that I'm overreading it, but it makes very clear statements about what quit claims do and don't do. I understood the argument to be that Geodyne says a quit claim means you assume the risk of the mistake unless there is fraud, misrepresentation, or mistake. Clearly that doesn't work. Geodyne says you assume the risk of mistake in a quit claim unless there's been some kind of misrepresentation. All right? And it says, well, the quit claim itself is not a misrepresentation because on its face it discloses all of these doubts. But in any event, it's a very short opinion. The court is welcome to take a look at it. It's included as attachment A. The reason this case in Geodyne is different from Hardy, the Hardy v. Benefield case that defendants brief, is that Hardy involved a warranty deed. It's the exact opposite of this case in Geodyne, which is what effect does a quit claim have on your ability to later claim mistake. All this turns on is, what did you bargain for and what did you get? They got a Lopco quit claim. They didn't get a quit claim from Mithril. So now that Mithril wants to enforce its rights, the defense is, well, this document we did get, okay, was agreed to under a mistake of fact as to who owned it. We thought Lopco owned it. But that's exactly the kind of mistake that they assumed the risk of when they took a quit claim, when they disclaimed all of the reliance, et cetera. Now, by the way, just to be clear, we don't offer the mutual release as affirmative proof that they assume risk. What the mutual release does is it shows that defendants had their knowledge, they were content with their knowledge after doing their investigation, and they weren't relying on anybody else's knowledge. And they continued to proceed in any event. That's 154 subsection B. That's the relevance and the import of the mutual release. I really think that's all I have to add there, Your Honor, unless you have questions for me to follow up with, I'd be happy to answer.
No, I've got a 3 o'clock juvenile board meeting tomorrow, and I plan to be here at the office all day and work on this until I get it finished in time for my juvenile board meeting. Unless it's very brief, we do not have time to take care of the motion to compel.
That's fine, Your Honor. We can address that at a subsequent hearing.
Really fine. Yeah, thank you.
Okay. Is there anything else we do today?
I mean, Your Honor, we potentially could have a discussion about scheduling. Obviously, the world has changed pretty substantially since we were last together when we were talking about a new trial date, and I just have no idea whether the court is even scheduling civil jury trial matters for next year. Mr. Terrest and I talked about some dates far out, but
we are, but I don't know where we're going. I don't know if the Supreme Court is going to back down and start requiring more restrictions. We put together a plan in Atascosa County. So we have a template for plans to do juries under COVID. And I don't know if they're going to come up with a vaccine and everything will get released. So I don't have a whole lot of insight.
Understood.
I hope that by the 1st of December that we'll have some guidance from the Texas Supreme Court.
Okay, understood, Your Honor. Well, we'll continue to confer amongst the parties, and check in with the court and we can revisit this at a later date.
Thank you.
Okay, thank you, Your Honor.
All right, and I will ask,
Judge, did you see my note regarding that waiver of arraignment on Roman Frausto? They had the
Yes.
wrong, okay,
they sent me a new one and I signed it.
okay, good deal.
Yes. Okay, well then I'll ask Ms. Riley to end the meeting and I'm gonna take off.
Thank you, sir.
Thanks,
Have
Judge.
a good day, everybody.
Thank you.
Bye, Lachey.
I'm not sure we're gonna continue that. It just depends how. Yes, there is. I'm not sure when they're gonna open it back, that back up yet. We are, yes, not correct. Which county? What's the last name of the petitioner on that case? Yes, ma'am, go ahead. And it's Gonzalez with a zero or S at the end. That's in the interest of children, the Gonzalez children. Kimberly and Richard. The next available, did y'all enter into the order or no? Yeah, because it had last day of 2/10 and there was reset upon a request, but never happened with it. Okay. December 3rd. 8. 10. Yes, ma'am, you're welcome.